everyone who just.
Okay, we now have a quorum and we will begin the closing the Justice Gap Working Group meeting. This meeting is being recorded. And before I do the roll call, we ask that anyone who plans on giving public comment to use the raise hand function to indicate that you'd like to do so. Now, with permission of the chair, we'll do the roll call.
Thank you.
Justice Tucker.
I'm here.
Mary Baldwin.
Here.
Becky Sandifer.
Here.
Marta Alkenbrock. Andrea Ruda.
Sorry, Mimi. Marta Alkenbrock is present.
Okay.
Apologies for the tardiness.
No problem.
And I see Andrew is also, he's just on mute.
Here.
Okay, thank you. Judge Wendy Chang. David Engstrom. Tom Green. Dan Grunfeld.
Yeah.
Eric Helland. Kathy Huang.
Here.
Micah Star Liberty. John Lund.
Here.
Kevin Moore.
Here.
Wendy Musell. Crispin Passmore.
Here.
Lucy Rica.
Here.
Toby Rothschild.
Here.
Jim Sandman.
Here.
Patricia Scutiero. Sacha Steinberger.
Here.
Thank you.
This is Jess Chang. I joined late.
Hi, Wendy. Okay.
All right. Thank you very much and welcome everyone. On public comment, do we have folks, Mimi, who've asked to provide public comment this morning?
It looks like no one has raised their hand.
Okay.
Oh, wait, you just got one. Stephanie Bond. Stephanie,
Please.
you'll have 2 minutes.
Can I be heard?
Yes.
Okay. This working group is claiming it seeks to solve the problem of access to justice. And it's a real problem in this country, in my country, or all around the world. Millions of people have legal problems. They can't get legal help that they can trust and afford. Trust is not a product of a government stamp. It's not a badge or a piece of paper. It's earned over time by goods and services doing what they promise to do. Have you ever figured out how they come into existence? If you had, you wouldn't be trying to pass more regulations to make them come into existence. The problem today is bigger than it's ever been. And regulations have been in existence for decades and they haven't solved the problem. In fact, they put more people in harm's way than ever before. The answer for this group has to be a new direction. I noticed that today's agenda includes a proposal about proactive law. It's claimed to be necessary to protect the public, but it's been tried before. It hasn't worked. It can't work. A proactive law treats the entrepreneurs like criminals. They're guilty, and they have to prove that they're not guilty. You can't prove a negative. Proactive law can't solve the problem of access to justice. In fact, treating the entrepreneurs like criminals is disgusting when they're actual criminals running around looting and burning and destroying property, and nothing seems to be being done about that. You can't micromanage every step that's taken. People have to be left alone to figure things out and be ready to deal with the problems when they arise. Reactive law is the proper way forward. What kind of risk is tolerable? You're going to be like an insurer, an entity that stands ready to respond. There has to be a level of risk tolerance that you can accept and deal with.
Your time is up.
Sandbox in California be a real sandbox, a real innovation.
Thank you, Ms. Bond.
And let the things happen.
Ms. Bond, thank you for your comments. We appreciate your participation. Ms. Lee, were there others who asked to provide public comment?
Nope, that is all.
Okay, then moving to the next agenda item, announcements. I actually have only one, and it's that in all of us in our inboxes just received, all the members of the committee just received a schedule for the 2022 meetings, both of the subcommittee and both of the working group and of our various subcommittees. So take a look at that and let us know if there are any conflicts with your schedule so that we can make sure and rearrange anything we need to, although it was pretty hard to come up with these dates, so hopefully that won't be necessary. And please note that there are some differences from the prior schedule so that you get the right dates in your own calendar. I also want to go over briefly what our agenda for today is. Everyone has a written copy of the agenda. You'll see that we have presentations which often happen in the middle of the day, but this time we're going to do them in the morning, starting at 10:30. We'll do a little bit of discussion before and a lot of discussion afterwards. I can't tell you exactly when our lunch break will be. We'll probably break around 12:30, but we'll see exactly how the agenda is rolling so that we don't cut it off in the middle of an important discussion. But going to plan to take a half-hour lunch break sometime between 12:15 and 12:30. With that, the next item is the staff report. Oops, I hope I didn't scoop them by talking about our meeting agenda.
We're good. We've covered the coming schedule that Lauren has just circulated. So please, when you have a chance, as soon as you can, please take a look at that. In particular, the notes that Lauren indicated with regard to some changes from the version that you may have previously reviewed.
Thank you, Randy. So the next item on the agenda is approval of the open session action summary from the October 18th meeting. If there was someone who attended that meeting who's prepared to make a motion, we would like to hear it.
Move to approve.
Thank you, Toby.
I'll second.
Can I make one suggested change, though? I believe that the minutes incorrectly state under business 2B that I presented that item. I believe that was Mr. Lund.
Okay, I can make that change.
I did 2A, but he did 2B, I believe.
Understood. Okay, I'll make that amendment. Okay, and who was the one who seconded the motion?
It was me, Dan.
Okay, Dan, and you guys.
Subject to the friendly amendment.
Absolutely.
Just making sure. All right. If it's okay, Justice Stuker, I'll go ahead and take the roll call vote.
Yes, I think we're ready. Thank you.
Okay, Marta Alkenbrock,
Approved.
Andrew Ruda, Mary Baldwin,
Approve.
Judge Wendy Chang,
Approved.
David Engstrom, Tom Green, Dan Grunfeld,
Approve.
Eric Helland, Kathy Huang, Micah Star Liberty, John Lund,
Approve.
Kevin Moore,
Approve.
Wendy Mussel, Crispin Passmore,
Approve.
Lucy Rica,
Approved.
oh, thank you, Toby Rothschild,
Approve.
Becky Sandifer,
Approve.
Jim Sandman,
Approve.
Patricia Scutiero, Satya Steinberger.
Approved.
Thank you.
Okay, thank you all. Then Becky, if I can call on you to start us off on what would be under our agenda item 2B business, discussion and possible action on recommendations on assumptions and empirical questions to test in the regulatory sandbox. I apologize that we will only barely get started on this before we have to break for the presentations, but would you like to kick us off here with a summary of the work that you've done that I think everybody has also had a chance to review in a memo you provided?
Yes. So at two different meetings of the scope subcommittee and then at a prior meeting of this full group, we talked about the evidence collection function of the sandbox. And so based on that conversation, the scope committee has sent forth 4 resolutions for the full group to vote on today. I don't know if we have time to pull those up really quickly. One of them is about an important role of the sandbox. One of them is about that there should be an evaluation of the sandbox. Another is about the kinds of data the sandbox should collect. And then finally, based on both the subcommittee meeting and the full group meeting, we have a list of questions that we hope are answered by any evaluation and data collection in the sandbox. So there are the 4 resolutions. And then the material that follows that are the questions basically to be answered by this data collection activity. Are there any, before we try to talk about anything, are there any questions just about the materials that have been provided? Seeing none, and being a person who prizes efficiency, maybe we could try to take these resolutions one at a time. So the first resolution says that a key function of any sandbox project is to collect evidence to inform decisions about legal services regulation policies. So what we're trying to get to is a vote from this committee on this resolution. Do we have any discussion of this first resolution?
Move to approve.
All right, so we have a move to approve. Do we have a second?
Yeah, I'm happy to do that.
Because I can. All right, then I'm going to hand it over to Justice Tucker.
All right, so I think we had 2 seconds on that. Both Becky and Crispin volunteered to second that one. Crispin, I think, spoke first, so we'll have Crispin as the second. Is there any further discussion on this point before we have a roll call vote on it? Hearing none, let's take a roll call vote.
Okay. Marta Alkenbrock.
Approve.
Thank you. Andrea Ruda.
Approve.
Mary Baldwin.
Approve.
Judge Wendy Chang.
Approved.
David Engstrom. Tom Green. Dan Grunfeld.
Approve.
Eric Helland. Kathy Huang. Mike.
Approved.
Thank you, Kathy. Micah Star Liberty.
Approved.
Welcome, Micah. John Lund. Kevin Moore.
Approve.
Wendy Mussel. Crispin Passmore.
Approve.
Lucy Rika.
Approve.
Toby Rothschild.
Approve.
Becky Sandifer.
Approve.
Jim Sandman.
Approve.
Patricia Scattiero. Satya Steinberger.
Approve.
Thank you. The motion passes.
All right, thank you, and it passes unanimously. Let me ask, since there wasn't a lot of discussion when Becky first asked, about the memo generally, it is possible that we can pass items 2, 3, and 4 also unanimously and perhaps without discussion, but I am not going to ask for a motion along those lines if there's someone who has concern about either item 2, item 3, or item 4. So is there anybody who would like to raise some concerns about any of those items? Crispin.
So not a concern, Chair, but just a comment for us to bear in mind as we take these forward, because I support them, which is that we should always be cautious about the burden that we put onto participants about the data that we collect. There's always a cost to that. And we should also be cautious about the format of that data. What we don't want to do is to say to businesses that are set up to collect data in a particular way, with particular categories, that they have to change all of their systems in order to collect data that fits us. This should be driven by their view of the customer need, and the customer's the judge of whether it's successful. And we should try to fit in with that rather than try and twist everything to fit our particular view of the world. So given that caution, I would support this.
So that's a helpful comment, especially in an endorsement of point number 3, which talks particularly about the need to strike that balance. John Lund.
Yeah, I also don't have a concern. I think this is a great conceptually. I just was interested in clarifying how this will fit into our overall report. This would be a set of 4 resolutions that we would pass, as I understand it. And then item 4 suggests that there's a list of other things that is the rest of the memo that would be the types of things to be studied, as I understand it. So maybe Becky could just explain to us, if we pass this resolution, how do you see this fitting into the ultimate instruction list or manual for the sandbox going forward?
So if we pass this resolution, then we're in part designing the sandbox, because we're saying that a key function of it is to provide information that would inform policy changes or policy stasis, as the case may be. We're saying that however it gets constituted, we're recommending that there be funding from some source for a rigorous evaluation. And we're also saying that there's a set of questions that subsequent reports would provide answers to. And those are the questions that the group identified under the categories of questions about consumer protection, about access to justice, about impacts on lawyers and legal services markets, and about the efficacy of the project itself. So that's how I see it fitting in. I don't know if that answers your question.
I think it does. And then I think if something else came up that somebody wanted to add as another topic to be studied, that's something that could be pulled into the report when we submit it.
I would think so, yeah.
Thank you.
Kevin Moore.
Okay, I'm not sure I'm just agreeing with John as far as other topics. If we're going to consider more than one resolution at a time, I would say, why don't you separate resolution number 4 out? Because there are some questions I have about the questions that we're trying to identify. So,
Okay, I appreciate that. Why don't you go ahead and bring forward right now what your questions
I would
are?
prefer, I have no problem with 2 and 3, but I think why don't we just put 4 at the end rather than just consider it all together. I don't see why
I heard
can
that, Kevin.
source.
I'm just saying, if you have some comments you'd like to make relevant to number 4, you can go ahead and make those now.
All right, clarification. Well, first, the big one is, I think one of the questions that we might want to ask is, what is going to be the impact on the court system, if any?
Okay.
So I would make that a 5th general topic that should be pursued, because one of the things that is discussed here is the increase, or I should say the reduction of the information gap and making people more aware of their rights. Will that have any appreciable effect on the court system? And are we going to make any recommendations as to funding of the court system, increased funding of the court system to address those?
So that's helpful. And one reason I want to elicit your input now is because when we get to we can do number 4 separately, but when we get to it, Becky may want to take on board in any proposal she makes, input she gets right now. Mary Baldwin.
I support the idea of severing off number 4. I suspect, but don't know, that we could probably pass 2 and 3 right now. I had a question too about some of the items in number 4, and I think that I would probably propose, I'm not proposing it right now, just throw it out there. I would probably propose for resolution 4 that we add at the end of it, to the extent reasonably possible, because some of these questions are so abstract. I'm not sure it's going to be easy to come up with a meaningful, matrix or empirical tools to figure them out. And then my second point is, I just don't understand what the word discoverable means under access to justice. How accessible and discoverable are the services? To lawyers, discovery has a particular, is a term of art, which means, can third parties obtain information about this through the course of, formal discovery served in, litigation or something. I doubt that's what's meant here, but discoverable to me is not a very clear term.
So Mary, that's a great point. Can I quickly ask you for the synonym you would like? So the idea is, can a normal person find this thing?
I'll think about that while we, now that I understand that's what you're looking for, I'll give that some thought.
And one possibility is simply taking it out on the theory that part of accessible is finding in the first place. Okay, other comments on any of the content of this memo? I'm not going to ask for a motion on number 4 yet, but I want all the discussion on number 4 now. Kevin?
Yeah, in the third bullet point under access to justice, when it says what kinds of entities, what do you mean by kinds of entities? Are you talking about ABS? Are you talking about more online as opposed to in-person delivery of legal services? I'm just curious as to what is contemplated by when you talk about kinds of entities.
So probably the sandbox in its construction will classify entities in different ways. Both of the ways that you mentioned are ways it's likely to. Another way would be for-profit versus not-for-profit. I think those general questions are contemplated by that item. But if you think it's necessary to be more specific, we certainly can.
Well, sometimes by being less specific, it is broader and it then encompasses, as you say, all the various options. Sasha,
if I could just add one thing is, I note that maybe it is here and I just didn't see it, but cost effectiveness of these services. Is that kind of baked into the other bullet points here? Or is that something that we might want to add as a separate bullet point?
Cost effectiveness for whom?
Cost effectiveness for the consumers of legal services.
It's certainly something we can add.
Sasha Steinberger.
Yeah, and this may be a little premature. I can't quite tell what needs to get talked about now and what's going to get worked out later. But in relation to 3 and maybe 4 too, just thinking about the data requirements, especially for nonprofits. I mean, for-profits presumably are building into their model money to cover people who help with that kind of stuff. Nonprofits are not going to have extra bandwidth necessarily to have additional people to do all the data collection and everything. So just thinking about possibly having even different requirements for nonprofit organizations that are trying to provide this work, these services. And then also related to 4, I guess, or the access to justice component, thinking about substantive outcomes and achieve for consumers, and thinking again, how to lift off a little bit from the providers where possible, especially when it's in an access to justice context. So thinking about what other markers we can look at outside of the individual organization's work. So things like if we're trying to reduce defaults in a consumer or eviction context, can we look at court proceedings in that area to see if we've reduced defaults more generally? Does it have to all come from the organization itself, especially again, when we're talking about nonprofits who may be stretched to provide all of this data? So just again, I think this probably gets worked out later, but wanted to flag, I think some of these again are going to be heavy lifts for a lot of organizations.
Thank you. Kevin, is that a vestige or do you have a new comment?
Yeah, I'll withdraw. I had one other comment, but I don't think it's necessary at this point. Thanks.
Oh, okay. Toby Rothschild.
Yeah, I wanted to add to Kevin's first point, I think it was, about the impact on the courts and whether that means more funding. Are we going to recommend additional funding? I think we ought to also look at, should we recommend changes in the way the courts function or the way that the legal system functions that might improve if there's this greater demand, if there's other ways that cases can be handled that don't require necessarily more funding for courts. Simplify the system.
So let me ask you a question, Toby.
Yeah.
That sounds like two different consequences of the main question about what impact on the court system, if any. Are you asking for something to be, are you proposing an amendment other than just adding Kevin's question, or are you pointing out some of the interesting consequences and endorsing Kevin's suggestion?
I'm endorsing Kevin's suggestion and suggesting that he mentioned in it additional funding, and I'm suggesting there's other things to be included other than just additional funding.
Okay. Got it. Any other discussion or suggestion that folks want to make on this agenda item before we actually, we may not even move to taking votes right now because I think we have speakers in the wings. Randy.
Just really quick, I thought Sasha's comment was a good one, and I'm wondering if it might be broadened to just include an issue regarding what different regulatory strategies, if any, ought to be considered for nonprofit providers. And that way, you pick up the burden issue of data gathering, but you also have a broad, open sort of canvas for other different things that might arise from what we learned from the sandbox in regards to specifically nonprofit activities.
Okay, so there are a number of suggestions, which is great. When we come back, let me ask someone from staff, is our first speaker here? Because I believe we were supposed to start that right now.
He has joined us.
Okay. May I ask someone on staff to do a brief introduction, and then we really very much look forward to hearing from him.
All right, yes, that's me. Just give me 1 second here.
In the meantime, I can announce that our visitor is from Upsolve. He is Mr. Rohan Pavuluri. I hope I'm not massacring the pronunciation of your name, sir.
No, it was right. Thank you.
Thanks.
Thank you for making the time to join us. Go ahead, Bridget.
Thanks. So we're really lucky to have Rohan here today. He's going to tell us about his story in founding Upsolve, which is a nonprofit that works on bankruptcy issues. And just a quick little bit of background, he graduated from Harvard in 2018. He's a member of the Legal Services Corporation's Emerging Leaders Council, a board director at National Access to Justice Center, housed at Fordham Law School, and is a committee member of the American Academy of Arts and Sciences Making Justice Accessible project. He has a lot of great stories from his clients and just his own experience working through the system. And we thought it would be helpful to give some examples of the types of things that might be offered in our sandbox today. Thank you so much for being here, Rohan.
Thank you so much, Bridget, and thank you everyone for having me. First of all, I just want to say it is so amazing that all of you and sort of this entire community is coming together to work on these problems, and I'm just so grateful to just be a part of it and to be able to do this work at a time when we're having this discussion. I want to start by sharing the story of 3 people I talked to recently who are low-income Americans who are sort of left out by our legal system. Williams, she is a single mom of 4 and works at a birth justice advocacy organization. Another guy's name is Christopher Lepre. He's a Navy veteran, union employed, works at an airport. And a third is Angel Torres, who is a nonprofit home care coordinator. All 3 of these people have something in common, which is that they sold cars that did not work by a subprime auto lender. The cars cost a couple $1,000s and they didn't work. So what ended up happening is they had to surrender the cars after they stopped making payments on a car that did not work. The company that sold them the cars ended up selling those cars for about the same amount as what the people who had bought them paid for. And then about 3 years later, for each of these people, they had lawsuits. And in some cases, the sheriff ended up garnishing their wages for a multiple of what the car was sold for. Now, the story of Erlen, of Chris, of Angel is not unique. Every year, millions of people in the United States are sued for debt, oftentimes by third-party debt buyers, subprime auto lenders, hospitals, for the wrong amounts or for debt that people don't actually owe. And when you're in someone's situation, in someone's shoes, when you're sued for debt that you don't owe or for the wrong amount, you most oftentimes can't afford a lawyer, and there are barely any free lawyers around to help people who have been sued for their debt. I was just looking at the statistics, and in California, 98% of people who are sued for their debt receive no legal representation. And it's not hard to imagine why. They're private bar to represent people who have been sued for their debt. It's pretty hard to make a living doing that kind of work. And there are just not enough legal aid lawyers around. So it is one of those clear areas of the law, people who are being sued for their debt and not able to get legal advice, where restrictions on who can provide and receive legal advice really harm low-income Americans. And the consequences of not being able to get legal advice when you've been sued for your debt are pretty tragic. They include deprivation of property along the lines of wage garnishment, along the lines of bank seizure, repossession, foreclosure, and the downstream effects of these include homelessness, hunger, poverty. So as I think about this, and the reason I'm bringing it up is it's the #1 area of the law where I see people who come to our website, upsolve.org, have legal needs that are unmet. And across the country, it's about 3 million people who are being sued for the debt and end up in default judgments against them. And I mean, I saw a statistic, 61% of cases filed in California do not include minimum documentary evidence that's required by the statute, which suggests that if people were able to get legal advice, they'd be able to respond. So this is one of the areas of the law where I literally do not think that we could ever have equal rights under the law unless we open up the supply of who can provide legal advice and who is able to receive legal advice. And I just want to sort of pinpoint and focus the discussion on that. And the other thing just to raise is every consumer legal aid lawyer that I've had the chance to speak to about responding to debt collections has told me that half the battle is filing the response, the answer form. And in the vast majority of these answer forms, it is not rocket science on how to check off the box. In California, there's a checkbox form. That's the case across many different states. So this is just one of the clear areas where I feel, because it's one of the most common civil legal issues that people in California face, I would guess that it's the second most common civil legal issue after traffic tickets that people face, where we need to find a way to empower people to get free legal advice so they can respond. And in a clear way, the restrictions on who can provide legal advice are subsidizing and enabling a predatory form of capitalism, because they're enabling these debt collection lawsuit factories to exist. So many business models are built on the knowledge that people who are sued for their debt are not going to get legal advice and are not going to be able to respond and are not going to be able to vindicate their rights. So I feel there's hardly any way you can look at this system and feel like it's working. If you look at the debt collection response process, there's a clear way towards thinking about how we might empower social workers, community organizers, union organizers, patient advocates, people who are already embedded in communities in need, who are already helping people with things like SNAP and Section 8 and Medicaid applications, to be trained to help people respond to debt collection lawsuits. So that is one thing that I think people in California would benefit from. And how I think about something that might exist is like the volunteer firefighter equivalent, where we train people who are not lawyers, but who are still professionals acting in the public interest, already have the trust of the communities they're serving to be able to provide advice to folks who are being sued for their debt on how to respond to debt collection lawsuits. And I think that that could make a big difference in people's lives in California and across the country. So that's just one thing that I wanted to share, something that I've been thinking about as how we can empower folks across the state, and happy to sort of talk through any questions that people might have. And one last thing I saw is that about 2/3 of cases in California where people are sued for their debt end in default judgment. So the court doesn't even consider the facts, and people's wages get garnished. In about 30% of debt collection lawsuits, people's wages are garnished.
Thank you very much for that brief presentation and for leaving lots of time for questions. Before I ask others to pose their questions, can I ask you to tell us a little bit about what Upsolve does and
Yes.
about what you might do if you were given an opportunity to participate in a sandbox in California?
Of course. So Upsolve is a technology platform that our first project helps people file for bankruptcy on their own for free. So I started Upsolve when I was an undergrad at Harvard. I was spending time at Harvard Law School's Access to Justice Lab, and we were working on these paper packets for people to solve their own civil legal problems when they couldn't afford lawyers. And I really came to understand that the legal fees that make low-income families pay in order to access their legal rights are modern-day poll taxes. If you can't pay the fee, you can't access your rights. And when you try to go it alone, you're forced to navigate modern-day literacy tests in the form of complicated legal forms. So I set out to explore how can we use technology to empower people with simple Chapter 7 bankruptcy needs to access their rights in Chapter 7 bankruptcy on their own. Because so many Americans face financial shocks when they lose their job. There's a medical emergency that throws you into 30, 40, 50K in debt. And when you're living paycheck to paycheck, one shock like this can really ruin your life. And bankruptcy is this safety net that helps you get back on your feet, re-enter the economy, improve your credit. But the cruel irony is that it costs $1,500 in order to hire a bankruptcy lawyer. So there's so many people in America who just can't afford to pay $1,500 to tell the court that they have no money. So what we ended up doing was creating a document assembly tool. You answer a series of questions in language you can understand about what you earn, spend, own, and owe. And then the forms generate, and then you generate your forms that you can take and file with the court. And we've been lucky to help relieve $400 million in debt for low-income families across America. So it's the #1 free nonprofit resource available to low-income families navigating consumer bankruptcy. And about 2 million people per year visit Upsolve right now to consume free education about bankruptcy, but also about wage garnishment, debt collection, eviction, repossessions, foreclosure, rebuilding credit. So how we think about Upsolve is something like Khan Academy for financial empowerment, especially as it relates to the legal issues that people face. And the reason I brought up debt collection is we would love to launch a project where we train people who are in these everyday social service settings, but are not lawyers. And we'd love to explore training them on how to help people respond to debt collection lawsuits. And we'd love to connect them to people who are ending up at our platform and who just don't have a resource right now and are just lonely and lost. Because it's so intimidating to go through the legal process on your own, as everyone here knows. So that's something that I want to do and would love to do, is be able to connect people who end up at our platform with folks in their community who'd be able to help them respond to debt collection lawsuits.
So I'll keep an eye out for people who raise hands with questions. But in the meantime, if I can ask one more, I understand that people who come to your platform sometimes, it's with your Khan Academy analogy, are looking just for information, but it sounds like you also have a document assembly tool, which sounds like your technology is helping people prepare their legal forms to submit to the court. I'm wondering, first of all, did I understand that correctly? And second of all, have you gotten any pushback from anyone that's treading into areas that only lawyers should tread?
Yeah, I mean, for the last 20 years, document assembly tools have always been around, so it's nothing new what we're providing with the TurboTax for bankruptcy like app. So, I mean, I think generally there's, of course, been a theme of whenever there's alternatives to lawyers, hey, like what's the right place for lawyers? What's the right place for education? What's the right place for professionals who are not lawyers? And of course, that's sort of what we're all talking about here. But if you think about any of our users, there's literally no other way they'd be able to access the bankruptcy system if it wasn't for Upsolve. And that's the value that we're providing to them and to low-income families in America.
So the bankruptcy lawyers have so far not come after you, or the regulators. They've just, everybody seems convinced that you're on the right side of the line, it sounds like.
And I mean, and just to be clear, it's totally free as well. So we never charge anybody for anything, and we have no plans to.
Then what is the income source that you use to support the project?
So by and large, it's philanthropic driven. So we have like great folks like the Legal Services Corporation, the Hewlett Foundation, the Robin Hood Foundation, people like Eric Schmidt, the former CEO of Google, Jack Dorsey, the now former CEO of Twitter. So these are some of the folks who have donated to us: Jim Breyer, early investor in Facebook, Chris Saka, Vinod Khosla, who some folks might know in California. So that's the vast majority. And then we do earn revenue from some people who visit our website who are not a good fit for our free service. They have the opportunity to request a free evaluation from a private attorney in their area who we vetted. And attorneys pay us fees in order to provide free evaluations on a per request basis to anybody who requests one. So regardless of whether they hire them or not.
Thank you. I see that Randy DeFrontorum has a question, and then Andrew Arruda.
Thank you, Rohan, for your very helpful presentation. I just had two questions. One is, do you have any insights on the sort of the demographics of your users? I don't know if you collect any anonymized or aggregate data like that, but I'm just curious if you had any insights on the demographics of the users, such as their economic sort of status. And the other question,
please,
go ahead.
Or I'll just jump in. I mean, the average Upsolve user is $225 in their checking account. They earn about $18,000 per year. Their average age is 38. They're more likely to be Black than the average American. About 60% are women. So really helping folks who, I mean, $225 in your checking account, the average bankruptcy lawyer, $1,500, means a multiple of the cash that people have.
That's great. The other question I had is whether you have insights on customer satisfaction. Is there any sort of feedback that you've received over the years, and generally what has that been?
Yeah, I mean, for the people who file, like the net promoter score that we have is near 100 of when it comes to how many people would recommend using Upsolve to someone else. We do have a feedback survey. We ask every single Upsolve user who has filed, and our success rate is 98% of people who have used Upsolve to file their forms. The people who don't get a discharge are the people who just don't show up to their 341 meeting or don't take the second required course after they file. So I can confidently tell all of you that nobody has been worse off by using Upsolve and filing their forms.
Excellent. Thank you, Rohan. I appreciate it.
Of course.
Andrew.
Hi, Rohan. My question really is about the art of what's possible in a world where California does offer a sandbox. I'd love to hear, and you've probably thought about this, and I think Justice Tusher touched on it as well, just in terms of what would be possible if, for example, you could charge users for certain services, depending on income levels, as a means to expand, or other services you think would be possible to provide that the current regulations might be not allowing you to expand into, or that you have some hesitancy to go into?
Yeah, I mean, like, look, the technology side, I am like obviously happy with what's going on right now. I think that the real opportunity is in engaging folks across California who are already embedded in communities in need, and who are already helping people directly with so many other issues that they have, like being able to provide them with, whether it's training, technology, software that could help them. Like, that's where I think there's just so much opportunity to scale. And there's so many people we're not reaching right now with their software that they're not like going to actively Google, hey, free bankruptcy assistance, or like, I need to file for bankruptcy. You don't even know what bankruptcy is, who I think about. So if I was to like be specific about a program that we would do if we could, it would be what I started talking about, which is helping people who are already in communities in need with debt collection defense, because that is such a big problem in California. I mean, it's hard to exaggerate. I mean, it's crazy. 4 million people in America being sued for their debts, and 3 million of those people having default judgments against them without any facts being considered. I mean, like, how can you call that a democracy? How can you call that rule of law? And it's pretty clear to me how the current restrictions on who can provide legal advice restrict the supply of help that's available, undermine our democracy, compromise a rule of law, and guarantee that we will never have equal rights under the law. So that's one of the clear examples of where I feel that's especially true.
Thank you. Lucy Rika, and then Marta Alkenbrock.
Hey, Rohan.
Hey, Lucy.
Question for you about the software. And that is particularly, I think, one of the concerns that many people have around software platforms that are permitted to offer more kind of fulsome legal services than the Scrivener type services that you know, they've been shoehorned into under the case law, is this idea of like, well, how does the software know when something's a problem, when something doesn't fit into the kind of decision tree that is laid out for the software, that is laid out for the particular legal issue? And so, you know, you mentioned before that you have the option for folks that don't fit into the platform, that don't fit to access free legal review by a lawyer. I'd like you to talk more about how the technology does that, because I think it's sort of, you know, state of the art now for many of these platforms, but I think there's a lack of understanding about how that really works, and like how that can be a really functional tool
Right.
that protects people from getting poor service where they don't fit in this particular platform's capabilities.
Right. So, I mean, I've always had a rule since day one at Upsolve is nobody should be worse off because they came and they sort of met us. Within the bankruptcy context, there are a few bright lines which sort of we have that we place from sort of experience, from just understanding sort of input from experts around like who we've decided to help and versus who Upsolve is not built for. And we have like disqualifications. We have a screener, but also disqualifications throughout while people are giving us information about themselves. And just to give concrete examples of what they are, it's like the median income. If you're above the median income within the bankruptcy system, that triggers a whole bunch of other forms that you need to file that are more complicated, known as the means test. So we don't help people with those. And I mean, of course, as a nonprofit that's mission is to fight poverty, if someone's above the median income, using Upsolve is not a good fit. Another example is a home. So the biggest risk in filing for consumer bankruptcy, besides losing your opportunity to file again, like by and large, is losing property that you did not think that you were going to lose. At the top of that list is losing a house, because that's the most expensive, most important property that most people own. So we don't allow people to use Upsolve if they own a house. So that's another example of where we've drawn that line. If you're expecting a personal injury payout from a lawsuit, or any lawsuit for that matter, there's complexity that triggers. So we don't allow you to use Upsolve for that. So, I mean, these are just a few examples of places where people cannot use Upsolve because we don't think software and self-service software is the best fit for them. So I think it's really important for entrepreneurs to be really thoughtful about who they choose to serve, and who is the right fit, because like there are definitely people, as all of our Upsolve users will attest to, but for whom this is a really important thing that should exist in the world. But there's of course people for whom it shouldn't, and we don't help them with our software.
Thank you very much. Marta.
Hi, thanks for coming today. Appreciate it. A couple questions. First, do you sell the data that you collect or that Upsolve collects on the clients that it services?
No.
Is that, so do you have any plans to monetize that in any way to further your services?
No.
Or Upsolve services?
No.
Do you share that data with any other, for example, the organizations that fund Upsolve?
Yeah, in an anonymized way, we like share demographics about like how many people we're helping, and the amount of debt that we've relieved, but we don't like share individual names with anyone like who is funding us.
Okay. Do you have any plans to make Upsolve a subscription service, or is the plan always to have Upsolve being a free service to the clients that it serves?
Yeah, I mean, like I don't have any plans right now for it to be a subscription service or to charge fees to consumers. Like definitely, like have always been thinking about, oh, what are potential like sustainability opportunities, but I mean, there's nothing that I have in mind right now.
And sorry for a bunch of other questions, but do you have, you mentioned that the bankruptcy, the assistance with bankruptcy is the first project that Upsolve has taken on. Do you have any other plans in the works beyond bankruptcy matters?
Yes, I mean, how I think about Upsolve right now is there's the self-service applications that we offer, there's the education that we offer, and there's online community. So those are like the three buckets of what builds the Upsolve brand. When it comes to the other domains, I mean, we've already created a lot of educational content for free on everything from repossessions to eviction to student loans to rebuilding your credit, to dealing with debt collection lawsuits, to Social Security disability, to veterans benefits. I mean, we have a lot of content around that. So to the extent that the question is about other domains, we have content around that. When it comes to self-service software, we're still exploring, hey, what is the next bet? Some of the things I'm happy to sort of share what I'm thinking about are Fair Debt Collection Practices Act, Fair Credit Reporting Act, FCRA. Continue to explore what are roles in debt collection defense for software too, and making sure people are on the right income-driven repayment plans, because a lot of people don't know about those. This is for student loans repayment. Another is helping people identify when bankruptcy is not the right option. Things like nonprofit credit counseling. So there's a few, and of course, like the axes by which we evaluate these are, of course, Upsolve's mission is help people sort of who are facing poverty. So poverty alleviation potential, how large is the problem, like how many people are facing this problem, how different are state by state differences, if at all. So those are just sort of how I think about this.
Is the content that you've developed, is that on your Upsolve website, or is that?
Yeah, you can check, just go to upsolve.org/learn.
And
I think lots of us will after your presentation. This is actually wonderful. Marta, I have to move them along because John Lund and Tom Green both have questions, and we are set to wrap up in just a few minutes.
Thank you.
Of course.
John, you're on mute.
Hi, Rohan. I've actually been on your website while we've been talking, so that's great.
Awesome.
Two quick questions. One, to follow up on Marta's question about data, would you just tell the group how you view the importance of keeping the data of your clients, private and protecting it? And, you said kind of flatly, no, you wouldn't seek to monetize it, but maybe articulate, how and why that's your point of view. And then kind of a second question, if we're talking in the sandbox about there being certain data requirements for people that participate in it. So we'd be looking for anonymized data, for example, about the number of instances of service and the type of service and how long it took to provide the service and the outcomes and those sorts of data points. My question there would be, what's your sense as a nonprofit of whether that would be a burden to generate that type of data if you had a project in the sandbox? Thanks.
I mean, on the data point, like, look, people are trusting you with their most sensitive financial information. You're a nonprofit helping them for free. I mean, your credibility is entirely connected to your ability to keep the data secure, keep people safe, and help people understand that you're really acting in their best interest. So I think about that every single day. When it comes to the data requirements, I'm glad you asked that. I do think a lot of this stuff can be a burden. I don't want for us here to repeat the same mistakes, for example, that happened maybe with the triple LT program in Washington, where you impose really high burdens on people, and then you wonder why nobody's asked to join the sandbox, like nobody's asked to be triple LT. So I think probably the best way to for me to answer that is yes, like it is something that I would be sensitive to in my own role as the CEO of a nonprofit. And but I think it's fair to impose some degree of data requirements and suggestions. So I think without seeing a proposal, maybe it's hard to talk about exactly what I think is fair and what's not, but should be a concern.
We'll make sure that you get a copy of what we put together as a proposal later next year, and we'll be interested in any comments you want to provide. Tom, you have the final question.
Well, I got three actually, but let me start. Hi, Rohan. Thank you very much for joining us. This has been fascinating. So three quick ones. What was the role, if any, of attorneys in creating the software that you use?
Yeah, I mean, so we employ attorneys, and we've consulted with attorneys across the country and judges and regulators from the very beginning. We've engaged with the U.S. Trustee's Office from the very beginning, and that's always been really important to me in my own role.
Okay, perfect. And then we have a special sort of regulatory system for document preparers. Are you guys, with respect to this software part of what you do, are you kosher under that as far as you know, or?
Yes.
Okay.
Yeah, I mean, as far as right.
Okay, cool. And then with respect to what you'd like to do with what sounds like social workers and folks that interact with people in need, what is it that you would like them to be able to do? What you would train them to do?
Yes, so I'll just be really specific. There is an answer form that people who are sued for their debt need to fill out when they've been sued for their debt. And I would like to empower social workers, clergy members, community organizers, union organizers to give individualized legal advice on which boxes to fill out based on a script that they ask people who have been sued for their debt. And how and whether to I mean, usually the answer is yes, but whether to respond and how to, and where to fill it out. And I think that alone would be really impactful, given how common that legal issue is among California residents.
Okay, and this is a little bit of an unfair question. Would that be encompassed in this document preparation exemption we've got in California? Do you have any idea, or do you need some special deal to?
No, I think it's legal advice. Like, I think people are giving you, answering questions like, how old is the debt? And it's legal advice, the response that you need. And I'm sure you guys are all privy to this, but the problem around the lack of definition of legal advice is this extreme chilling effect. And I think it's actually a fair question what you asked, Thomas, because that's the problem here, is that you don't know what legal advice is versus what's not. You ask two different people, you get two different answers oftentimes. But I think this squarely fits within legal advice, and it's something that you're chilled from doing. I don't know in California if there's even criminal penalties, but in many states there are.
Sure.
And even if it's free, even if you're held accountable to it, even if it's narrowly circumscribed, even if it's vetted. To me, that is a great injustice. It's a civil rights injustice that exists in California. And we should be really talking about all these UPL issues as anti-civil rights policies that are really harming low-income families and enabling a predatory version of capitalism, as I'm talking about in this debt collection example. So that's why I'm so glad everyone here is working on reforming them. And thank you so much for the invitation, guys. I really appreciate it.
Thanks, Rohan.
Thank you very much for coming and sharing the wonderful work that you're doing with all of us. And keep in touch.
Thanks. Thank you so much. Take care, guys. Bye.
With that, I should ask Bridget whether Erin or Randy, if you know whether Erin Levine is here.
Yes, Erin Levine is with us.
There she is. Hello. Hi. Hello and welcome. Thank you for being with us. I'm going to ask Bridget briefly to introduce you, and then we really all look forward to hearing from you.
I think Becky is going to. Do you have?
Oh, Becky, excuse me.
That's okay.
No, it's my pleasure to get to introduce Erin Levine, who is a lawyer and an entrepreneur. She's the founder and the CEO of an organization called Hello Divorce, which is currently operating in Utah's Sandbox. She's been advising clients, litigating and negotiating and mediating both contested and cooperative divorces for over 15 years in her respected boutique family law firm in the Bay Area. She's pursued developing Hello Divorce because she became disillusioned with the system that routes every divorce through court, pitting spouses against each other. And so she set out to create an online, ethically compliant divorce service. So thank you so much, Erin, for coming to talk to us today. We look forward to what you have to say.
Thank you so much. It's an absolute privilege to be here. I am honored and grateful to be a part of this conversation. A little bit nervous to follow Rohan because he is such a genius and doing so much great work out there. But I'd love to share a little bit about what we do at Hello Divorce and what we would do if there would be a regulatory sandbox. So I'm going to share my screen because, as my daughter said, I always have a slide presentation for everything. Does everyone just see the slide on their screen, that first one? Okay, great. So a little bit about me, for those of you that don't know me. I was licensed to practice law in 2005. In 2009, I founded Levine Family Law Group. I litigated cases for many, many years. And in 2014, I became a certified family law specialist. At that point, I instituted in our firm a requirement to do pro bono family law work, which everybody groaned about until they started doing it. And then they absolutely loved it. And as they started to do it, we received recognition. Alameda County Bar Association gave us a pro bono leadership award. We started to do more research because we started to pay attention more. And we saw so many people that were going to court without real meaningful help. And they are dissolving the most complex contract of most of their lives, right? The divorce, the marital contract, and they were doing it alone. And so I knew we had to do better. So in 2018, as part of our law firm, we launched Hello Divorce. We also won the Duke Law and Tech Accelerator Grand Prize and started to sort of embark on this journey of seeing how we could help the 75%-ish of cases that have at least one self-represented party. So in 2019, I pulled Hello Divorce out of our law firm. We won the Reisman Award for Legal Innovation. Early in 2020, we, just before the pandemic hit in a way that we really understood it, the American Bar Association awarded us the Excellence Award in e-lawyering. And then 2021 has been very exciting for us. Cornell Law School students helped us build out New York, which we are about to launch. And I raised a $2 million seed round. You all know this, but as a reminder, divorces are expensive. In California, according to USA Today, the average divorce is $26,300 per person if you have children, and about $17,000 per person if you don't. Divorces are absolutely messy. The best way we have known to resolve conflict is to route people through court, because that's all the resources that we have available. It's very overwhelming. Even to get something as simple as a status conference form scares people. They think that their spouse has done something to bring this into a war and litigation. So, and then top all of that off, divorces are very confusing. California has 30+ mandatory forms. Many of them say optional, but in most counties, those optional forms are mandatory. And there are a ton of DIY self-serve services out there, but really that's not actually enough for most people. So my vision is to increase access to justice, primarily the people that wouldn't hire a lawyer anyways because they can't afford one. We are working on shaping the legal experience for the greater good, taking pressure off the systems and courts. In California alone, even though we are launched in several states, we take 200 to 300 cases off of the court's docket every month by settling them out of court. And then also, I'm a lawyer. I love lawyers. I want to elevate the public's perception of lawyers. I want to help set the tone and create economic opportunities for lawyers who are seeing the writing on the wall, that consumers don't want lawyers to handle all of their legal problems or can't afford it. And then, of course, the most dear thing to my heart is changing the conversation around divorce, replacing stigma and overwhelm with peace of mind, giving people the education they need to make good decisions for themselves, to help reorganize their families in a way that makes the most sense for them. So goal number one, create an easier, friendly, and cheaper alternative to most divorces. So we are an innovative and ethical service that consumers love. We combine, like Rohan, we have self-service technology, but we combine that with customer support and attorney services because frankly, after a design sprint and working with thousands of people, that's what consumers want. So lawyers built the software with our developers. They're intimately involved with us as we build out and iterate on our software all the time, looking at where people are encountering friction and how we can help them move through that in a more meaningful way. So I'll share my slides after this. I'm not going to go through all of them because I know you want me to get to the heart of the matter. But you'll be able to see a little bit about some of how our customers have responded, a little bit about how the app works. And then probably important to you is how it's paid. So it looks like a subscription service. It's not. It's actually a flat fee, but most people can't afford a flat fee. And we want people to be able to choose the service that's best for them. This is not for contested divorce. This is for divorces where people already have an agreement or are committed to working towards an agreement. So our current model is requires me to run a company through 2 entities. Fortunately, I'm a lawyer, so I have that opportunity, and spend honestly thousands and thousands of dollars to navigate these regulatory boundaries. Our clients obtain legal advice in California from Levine Family Law Group. So they actually, when they engage Hello Divorce, if they also want to get legal advice, they sign a separate fee agreement. Funds are deposited 100% into Levine Family Law Group, and Levine Family Law Group then pays the lawyers. So what does that mean for me with all the difficulty in making that technology work and ensuring that we have great lawyers? What it means is that the least profitable part about my business, in fact, the part that makes absolutely no money, is the lawyers. But I know as a lawyer that most people need or want to access a lawyer, so I make it part of our model. So why isn't Hello Divorce a law firm? Well, the reason, and believe me, I agonized over this for months and did so much research. But the bottom line is this: to work on really helping people access the legal help that they need, you cannot do it alone. Lawyers have yet to be able to solve this problem. And so I really needed to bring in the talent. I needed developers. So I first partnered with an incredible firm that works a lot with LSC, A2J Tech in Colorado, so that we could do a revenue share so they could help me build out. I needed better content. I needed to explore building in multiple languages, accessibility. I needed to attract talent in product. I wanted to build on the divorce ecosystem, because people who are getting a divorce, they do have to go through the legal system, but they have a lot more on their minds than divorce. I could not do that in the context of a law firm, because frankly, I went from earning a ton of money as a law firm owner to making nothing as a startup founder. So I didn't have those funds available to me. I had to raise money. I had to go seek talent and other people that were willing to put their livelihoods on the line because they believed in the mission and they wanted it to succeed. But I have a big problem. And that is that I can't collect legal fees directly, even though I have lawyers employed and I have some of the most talented paralegals on the planet. I can't collect legal fees. So that all has to go through Levine, which creates a lot of problems. I have lawyers and all over the country, but we're talking about California today, that always are sending us threats about unauthorized practice of law, not backing it up with any law or regulation, but are constantly on our backs. I'm constantly having to pay our ethics attorney to help with this. Our paralegals can't be paralegals. And here's the problem there. The problem is that paralegals are absolutely amazing. They know how complicated the system is. And during the pandemic, it has become an ultimate nightmare. One example is this. In the middle of the pandemic, San Francisco, tech capital of the world, decided that they would not take the e-signatures that our consumers had used to sign their name on petitions. Not only that, but they had decided that if you had filed a petition with an e-signature, you could no longer, that did not serve as valid. You had to refile and reserve. You can imagine the complexity that this must have put on self-represented folks. We ate that cost. We did it for them, but it was not ideal. It was a nightmare. And only paralegals really understand how to navigate the system to find out what these rules are that change constantly county to county and how to help people navigate through them. But what I've had to do is start to hire people that have no experience in the law. And I've had to give our paralegals over and over again training on UPL, unauthorized practice of law, so that they don't do anything or say anything that relates to what their legal training consists of. And then of course we can't offer legal advice. So an integrated model with a sandbox. I think it's good for lawyers, opportunities for work-life balance, professional growth. They can earn stock in our company. They can service more of the market. The lawyers that do work with us love the work that they're doing because they're working with consumers that actually want to resolve their problems, not fight it out in court. It's great for customers because we are 100% customer focused. We would also deliver services that that would be integrated, easy to regulate because you can oversee the whole model rather than so much of it being out of reach or compartmentalized. And of course, it's great for Hello Divorce because we can grow the business into other areas of law and service clients that with their needs beyond the law. So if you get a chance to review my slides, I've pretty much covered it all, but ultimately, we don't want lawyers to be afraid to work with us. Like that is a big problem right now. And and we want to be able to deliver this integrated service that makes it so much easier on lawyers and investors to understand and engage. And we want more flexibility with our service offerings. We really want to be able to say that if somebody has a question and needs some legal advice, they can answer it. Not that they have to go through several different routes just to get that legal advice that they need.
Well, thank you very much, Erin. I think you and I probably first encountered each other when I was a family law judge in Alameda County, and you would appear in front of me. So it's very exciting to see what you've been doing in the intervening years.
Thank you.
I think Tom has our first question.
Hi, Erin.
Hi.
Are you this integrated approach, or is that happening only in Utah, or you're doing this in other states as well?
No, so we've been approved in Utah and we've developed our integrative approach. The problem has been is that we've been unable to launch fully in Utah. I mean, we are live in Utah, but we still have the 2-entity model. The actual integrative approach doesn't launch until January. And the reason is because up until July of this year, I've been completely self-funded. So to have technology that offers a different service in every state is really challenging. So it's taken us a little while to figure out how we can do it. Now, that being said, the same legal professionals and lawyers that currently and mediators that currently work with us in Utah will continue to. They will just now become employees of Hello Divorce that we can supervise and work together as opposed to contractors of Levine Family Law Group.
Perfect. And then this seems just infused with lawyer input and lawyer supervision. What rules did you need waived in Utah to make this work? I mean, it just seems to me this should be acceptable from a regulatory perspective. What is it in this model that needed exemptions?
Fee splitting, unauthorized practice of law, the ability for lawyers and paralegals to give legal advice for lawyers and paralegals to be able to provide upgraded service. Right now, what they have to do in most states is take the forms as generated by the software and file them as is. In California, with all of ours are also legal document preparers, they can review the forms. And then if the client wants to change the answer, they can verbatim put that answer down. But they can't say, hey, I think it's a good idea for you to talk to one of our lawyers. There might be an issue here. This is pretty complicated. Or, hey, this, it sounds like you want to say this, or you may have missed, I saw in your financial disclosures, you put a house, but I don't see that in your agreement. Should I include it? Those are the things that we can't provide, Hello Divorce can't provide, unless there's an ability to practice law within the company and to share fees, to bring some of those fees into Hello Divorce so then we can pay our team.
Great, thank you. That's very helpful.
Crispin.
Thanks, Chair. Hi, Erin. Just one question for you. Can you say a little bit about why the need for changes helps investors and why investment is so important to your business?
So lawyers, we all want to think that we can fix everything. And what I find is that what I found very quickly is that the way that we talk and the way that we explain works really well for judges and other lawyers, but not well at all for consumers. And so I really saw the need to bring in people that specialize in content and user experience and how people flow through technology and that kind of thing. When I initially approached investors, I said legal technology and nobody wanted anything to do with us. The first 50 investors said, absolutely not. Those regulations are crazy. We are not going to help. And then they'd also seen like devastating results from DIY, from people like trying it on their own without having any access to like other services and whatnot. And so they really stayed away. I changed it to Justice Technology and it was helpful, but I have to say that during due diligence, like I spent months and months explaining to people the two entity system and how it can work and why they should invest. And as you can imagine, because we can't monetize the legal piece really, that's the least interesting part to them. So it took a very, and the scariest part to them. So it took a really long time. And I was fortunate enough to find investors who really understood the holistic approach and wanted to include lawyers. But I'm lucky. I'm one of the lucky ones. I don't think that most founders would have that, privilege. Did that get to the meat of your question? I know I went on a tangent.
Yeah, thanks.
Mm-hmm.
John Lund.
Hi, Erin. I don't think you and I have ever spoke directly together. It's great to hear you talk about Hello Divorce. I have a couple questions. Maybe one you heard me ask Rohan, and that's about the data that you get and what you do with it. And then related to that, given they're a fairly tech strong platform, is it practically possible to like supply the data that Utah is asking you to supply? Is that doable, or is that adding a lot of cost to what you're trying to do? That's a question I have.
Yeah, great. So the data is like we weren't set up to be able to provide the data. However, I was willing to do it manually because I believe so much in this. And I also believe that our data will be really helpful to regulators to see how happy consumers are and how successful they are. But we had to get smarter with our data. It just happened to be that at the same time, security has always been our #1 priority, but getting smarter with our data, collecting it so that's all in one place, and that it's easier to give to Utah, happened to be at the same time that became a priority for my company. So that is no longer something that I'm particularly concerned about for us. We will be able to provide that data. What was harder is like being able to offer different offerings in other states with the limitations of the website as it is now, which is being redesigned. We will never sell our data. We are not a dating app. Like that is not what we are. And we know how evil that is. We use our data to figure out how we can better serve our customers. And this was really interesting to me because as a law firm owner, we would see a few hundred cases a year of people in a very high socioeconomic bracket. But now we have all this data from people all across the board that are helping us to understand what their needs are. They are finishing their divorce and they're not unsubscribing from our email list. They're asking us questions like, how do I change my name? And is now a good time to file bankruptcy? And I think I need a new health insurance plan. Where do I go? I mean, these are things that we can ultimately help with and improve the user experience, but it won't go outside of Hello Divorce and the data will always be anonymized.
Well, that kind of touches on the other piece I want to ask you without, giving us the whole prospectus. You had to make an economic case for investment, right? And did you use sort of what you had learned about consumers, or how do we begin to demonstrate that there really is a market out there of people who have, some ability to pay for some level of service in the manner in which you're delivering it?
Well, we're demonstrating it now, right? With, we've been growing. We launched in 2018 and have grown 100% or more year over year. We have a product that is $20 a month for 6 months. And we have just recently integrated with a firm, although it's not live yet, so that people can make payments and hopefully be able to afford a higher service offering if that's what they need. But it is very important to us that it's not just the service offering, but that they have the content that they need, that they have the information, that the system is as transparent as possible so that they can navigate through it, even if they can't afford like a higher service offering. I totally lost my train of thought in your question. Can you remind me?
It's just about the economics of it and
Oh,
you know,
yes.
assuring folks there's actually a market out there. If you build it, will they come?
Oh, yeah. Everybody like that. The market wasn't hard because everybody knows that like divorce lawyers cost a fortune and that most people can't afford it. Everyone also knows that that while there's only about 2 million people get divorced every year, that is not the end of the life cycle, right? Most people end up needing to do their co-parenting plan and redo it, recalculate child support and that kind of thing. But honestly, that's not what excites investors the most. They are excited about, at least for us, and at least as long as we can't monetize the legal piece, is the financial tech offerings that we will be doing as well. I also just want to say that that most companies to sort of avoid this regulatory landmine, they're doing two things, right? Either a marketplace of lawyers, which I think is very problematic. We don't need another marketplace. You have no way to control quality that way, or a legal plan. And the way these plans make money is to get people not to use the services, right? And so we want people to use lawyers. We had to figure out a way to sort of use that so that we can also subsidize some of the lower end services as well.
Andrew and then Lucy.
So first of all, big fan of what you're up to. As I've always told you, it's really wonderful. I guess two questions. My first is, how have you seen the response, and more specifically, the negative response from practitioners been? If you could share a story or two about that. I think it's important for the group to hear like how hard it is for people who are trying to do something different in the space. I think that would be really helpful. And then the second question would really go to, you mentioned some of the rules that you would like to see change. In terms of people who don't come from legal backgrounds, what is their role and how would you like to see that expanded in a way that could potentially help you and what you do with Hello Divorce?
Yeah, you might have to repeat the second one because I'm not great at okay, so every state is different. So for example, in Texas, the state bar doesn't seem to regulate UPL. The Supreme Court there authorizes practitioners to be able to file complaints, which is exactly what's happened. So we've been able to resolve those. The biggest concern was like that Texas lawyers thought that we were having California lawyers give advice to Texas consumers, which is exactly not the place. The one change that we have had to make is that our 15-minute calls that we offer for free, which is really important to consumers because for some of these people, it's the first time they're saying divorce out loud. They need someone warm, and we had to make sure that we no longer called it planning or strategy or anything that could potentially say that we're giving legal advice when we're not. So we had to make some changes there, but that was reasonable. California, I always get people that say, lawyers that say we're cheapening the profession, that they don't pay the state bar to do access to justice work, that everything you can imagine in the book, emails and phone calls about how this is like going to destroy the profession. Our lawyers are making as much or more that they made before, just to put that out there. And they will tell you that they're happier. We also, I'm on listservs because I'm a certified family law specialist. So either they don't know that I'm on it or not, but I oftentimes, and I love forwarding these to Crispin, will hear these long conversations engage about all the problems with this type of model, specifically that when somebody has a really a majorly contested divorce that is in court and litigation, this won't work for them. And we absolutely agree. And we're the first people to say that, hey, we'd love to help, but we can't.
Thank you. Yeah, the second question was just about expanding the role of folks who maybe aren't lawyers and maybe aren't paralegals, allowing them to offer advice where you think appropriate, and the benefit to that might, in terms of expanding maybe even beyond divorce or deeper into what you'd be able to offer.
So, I mean, I think, allowing our paralegals at a minimum to act more independently, to be able to revise basic judicial counsel forms, let people know when they think that there might be a legal question and they might want to consider talking to a lawyer. That to me would be ideal. I think the hardest part about navigating this whole thing are the blurred boundaries. And like Rohan said, not being able to know, there's no clear definition of what it means to do unauthorized practice of law. So we had to scale back everything and really hold back content and information that would be really, really helpful to consumers. I'm not prepared to speak on the type of person, that could or should be giving advice at this point. What would be most helpful for us and our model and innovative models like this is to allow lawyers and paralegals to do their job, whether or not they work for a law firm, so long as they are appropriately supervised.
Thank you, Lucy. And then Marta.
Hi, Erin. A couple of quick questions. So one is, you said a couple of times as you were explaining what you're doing that you cannot monetize the legal piece. And I just wanted to clarify, do you mean that under the current under the traditional regulatory regime where you can't bring outside investment into the law firm piece, the outside investment can only go to the tech company piece? Is that what you were talking about?
Right, but also anything that people pay for legal fees has to go to the law firm. And so and it's very, very tricky to structure a payment from Levine back to Hello Divorce that doesn't implicate all sorts of other regulatory issues and problems. And so Hello Divorce can't accept any fees for legal fees. We can't, it all has to go to the law firm.
Okay, that's helpful. And then the second piece of this was in a sandbox context, whether Utah or potentially California, when you're making your pitch to investors, or when you're thinking about, this unified model where that separation is not in place, how are you framing the limitations of the professional independence of the lawyers vis-a-vis outside investment? How do you frame that for the investors? How do you frame it for yourself? What sort of policies do you put in place to ensure that, lawyers' independence of judgment remains sound, their ethical duties remain sound in spite of this additional outside money coming in, this outside ownership, this quote unquote corporate form?
So the lawyers themselves, if they get paid for their job, they won't get it. So part of it is how you structure how you pay them. If you pay them a salary and give them KPIs, which include doing great work, customer satisfaction, giving helpful advice and that kind of thing, then I think that's how you control it. So you have adequate supervision, you put in lawyers and other members of the executive team to help supervise the lawyers. You pay them fairly, you have them do their job. I don't if the concern is that investors are we haven't had any investors say that your product, it can't change substantially, because then consumers wouldn't be happy at all. So I'm sure that all of you have dove dive deeper into this. I'm sure I could too. I like the way that we are set up, the culture that we have. There's no expectation that the lawyers wouldn't be paid for their work properly and that they wouldn't have the ability to give advice. They'd still have the attorney-client confidentiality and privilege. There still would be issues around not having conflict of interest. Like all of that stuff would still be there that ordinarily regulates lawyers. The only difference is they'd be paid by my corporation instead of by my law firm.
Thank you. Marta, I think you get the last question. But you're on mute.
Apologies. Thank you. It's been a great presentation. Why are your attorneys making the same amount of money that they would that they were making in an ordinary practice now with working for Hello Divorce?
We've still had to, because we have such a lack of flexibility, we still have to charge the consumer by the hour. And so while our hourly rates aren't as high as they are with the law firm, that still leaves, they're still high enough that leaves a big enough profit to Levine to be able to pay them for their time, but also they can do more volume because the technology is doing so much more. All the tedious tasks and things that lawyers ordinarily, especially small firm lawyers, usually spend their time on that they can't bill, they don't have to do. It's all taken care of. The scheduling, the first draft of the forms, the customer is coming to them with legal questions only. Everything else has been resolved for them, either by a staff member, the technology, or the content that they've read. So their volume is higher, but they're doing what they actually love. They're solving legal problems, and they can, and while the hourly rate is lower, they still are able to net a pretty solid amount.
And why would you have to, I mean, if I understand what you said earlier, the reason why you would have to enter a sandbox if there is one in California is because you would have to get money from investors. Is that correct?
That's one reason why we already have money from investors. We'd like to continue to raise, but we also need to attract talent. And one way that you do that is you pay people less money with promises of equity in the company, but you can't do that if you're a law firm because we're not allowed to have non-lawyers own law firms.
So your paralegals you would offer them equity in the company. Is that correct? Because you can certainly have lawyers own a piece of Hello.
Developers, product managers, people that are helping with user experience, accessibility, language stuff, customer experience, customer success, all of these people, specifically on our executive team, that are doing everything in their power to help people navigate this super complicated system. We can't afford the large salaries that companies like Uber and TurboTax, Intuit, and others can pay them. We can't do that. So you have to make, like any other startup, any other innovative approach, we have to offer them equity so that they're invested in providing this amazing outcome for consumers.
Would your hourly rate go down then once you are fully maximized your whatever money you're trying to raise? I mean, what I'm trying to see is, I mean, one of the goals here through our working group is to get access to justice to people who can't afford legal services. And what I'm kind of understanding is that your clients aren't getting that much of a discount, if at all, at this point in time. Is there a plan that your services would go down in price?
Yes. So first of all, they are getting a discount when you think about the number of hours that they need a lawyer with our system versus if they were just to go with a lawyer. So the 2 hours that they spend with a lawyer here is more like 10 or 15 in a traditional law firm because we're taking so much off the lawyer's plate and the customer can get that with software. But secondly, yes, if we are part of the sandbox, we wouldn't need to do hourly. We would have an integrative service, right? Where people get what they need based on a fixed fee. Right now, we have to do hourly. That's the only way that we can split it out. So that's really clear to the state bar that people are only being charged for Hello Divorce for non-legal work, and that the legal work that they're doing is specifically like over here, compartmentalized with a lawyer at a law firm. So there's so much that we can do to bring down the cost of lawyers. I know we don't have time now, but this is something that I've spent hours and hours and hours of time researching and working on with investors so that we can bring the costs down with lawyers if we have an approach where we can subsidize or take it from other areas and bring in more talent to continue to build out our technology.
Thank you.
Erin,
Thank
that's
you.
a wonderful place to end. I think your presentation has been absolutely fascinating. I hope you'll keep in touch with us and us with you as we go forward.
Thank you.
Really, really appreciate your insights on the interesting work you're doing.
Thank you so much.
Thank you.
With that, we will revert to the conversation that we were having before those two wonderful presentations, which means we'll go back to Becky's memo. And we had a collection of questions and comments that people were making that were relevant to question 4. But what I'd like to suggest is that what several people said that they didn't see any controversy about numbers 2 and 3. So I'm going to ask Becky whether she wants to make a motion that would address, well, I'll leave it to you, but perhaps numbers 2 and 3 of your proposed resolutions.
So I would like to move that the group approve resolutions 2 and 3 with the point about the resources to do data collection that's underneath 3, move to the footnote as an example of the things that should be balanced.
Second.
So let's make sure we have clarity on what we've done since we've just moved something to a footnote. The footnote will read, let's see. Are we going to have a third sentence that addresses profit and nonprofit? Or are you just going to leave it the way it is?
I would put in another sentence that starts out something like, to take another example.
All right.
Perfect.
For-profit and nonprofit providers may have different financial resources to do the data collection. All right. Any questions about what we're about to vote on, numbers 2 and 3 with the revised footnote, or any comments before we call the vote? Hearing none, Mimi, please do your thing.
Okay, Marta Alkenbrock,
Approved.
Andrea Ruda,
Approved.
Mary Baldwin, Judge Wendy Chang,
Approved.
David Engstrom, Tom Green,
Yes.
Dan Grunfeld,
Yes.
Eric Helland,
Yes.
Kathy Long,
Approved.
Micah Star Liberty, John Lund,
Approved.
Kevin Moore, Wendy Mussel, Crispin Passmore,
Approved.
Lucy Rica, Toby Rothschild,
Approve.
Becky Sandifer,
Approve.
Jim Sandman,
Approved.
Patricia Scutiero,
Approved.
and Sasha Steinberger.
Approve.
Thank you.
All right, thank you all. Becky, am I rushing you to ask whether you have a proposal on number 4, perhaps with some amendments?
So I think John Lund, very early in our conversation today, made the point via questioning, like the good litigator that he is, that this is not, if we say, hey, these are important questions, does not limit us to these questions for all time. So in the same way with the application, we said, we want to know these things. We may want to know other things later on, but this is our thinking now. I would propose that we go forward with 4 as it currently is, with the understanding that we may add to this as our thinking evolves going forward as a group.
Okay, so your motion is, to the extent any blue stuff has been added, ignore it, but instead just move on the, you don't have to take anything out right now, Mimi, but your motion, Becky, is just that we go with the version that was distributed in the memo and that was reflected without any blue on the screen here. Is that correct?
The amendment I would accept, I mean, for the purposes of just the resolution, I think the questions are all great, is the to extent reasonably possible part of 4.
Okay. You also had previously suggested you might be open to a change under access to justice, where the question was phrased, how accessible and discoverable are the services? Either deleting or modifying the words and discoverable.
And I think your point about accessible includes, can you find it, means that sentence could stand by ditching and discoverable, would still mean the same thing.
Okay. And then, so those are 2 amendments to the original version. And then are there any other amendments or additions that you want to make in your motion?
I am happy with this.
Okay, do we have a second for Becky's motion?
Second.
Came from, was that Toby?
Yeah.
Okay.
Discussion?
Any discussion?
I do have a question about how to the extent reasonably possible relates to consumer protection. It strikes me that under consumer protection, one is consumer complaints, second one is malpractice filings, and the third is violations of ethical rules. Why is that to the extent possible? Those strike me as crucial pieces of data. This is not a to the extent you get around to it kind of a problem, it seems to me.
So Tom, I think that's an excellent point. I guess my response would have 2 points. So one is, there's a whole other part of this project that's setting up the regulatory function. And that's not what this is. This is the understanding function of the activity. And so when we talk about what the SAGE group has come up with, that will necessarily have important roles in what information gets collected, right? So I think it's not, that will not be lost by any means. I think in terms of, I mean, it's the thing that's to the extent reasonably possible is how definitively can you answer the question? So let me give you an example from the way we do things now. So the way we do things now is we wait for people to make malpractice claims against lawyers or to make complaints against lawyers. And that's the extent to which it's currently believed to be reasonably possible to assess consumer protection with lawyers. But of course, we know that lots of stuff happens that we don't capture with those means, right? That's true of any method of monitoring the world. I think Mary's amendment was meant to be, you could make this into a $7 billion evaluation and a $7 billion sandbox data collection project, and that's not reasonable. So what is reasonable within the context of the time frame this thing will have, the resources that will be available, and the actual kinds of information you can capture about things that happen in the world. So that's the way I think about it, but I certainly would invite others to share their perspective on that.
I do think, Becky, at the very least, you need to say that maybe this is a footnote under the 3rd bullet point and suggest that that point and above, that we do expect that this information will be made available to the entity and to the regulator, and appropriate actions will be taken based on that. But the notion that the extent to which this might suggest that consumer complaints, malpractice filings, and violations of ethical rules are somehow kind of optional pieces of information in this process, I think is a pretty big deal.
Looks like Toby has a comment.
I'm sorry, Toby, go ahead, and then Crispin.
Yeah, I think that it needs to be understood, and maybe it needs to be said in some way, that for each of the bullet points under each of the categories, more or less may be reasonably possible in different circumstances. So it may well be that those first 3 bullet points under consumer protection will always be mandatory and complete, that the 4th bullet maybe in some circumstances will be required. In some cases, it can be modified. I think that we can't at this point go into the great detail. It's just as to each of these things, to the extent they're reasonably possible, we should do them. And later, as we get into, as was mentioned, the SAGE actual implementation of it, that we'll get much more detail on this. This is just the starting point.
Crispin.
I think the point about the importance of the consumer protection and malpractice data is well made. Of course, those things are always going to be needed, but I'm not sure we need to change the language. I'd love to hear the argument that that sort of data is not ever going to be reasonably available. It's simple to collect. We're going to have easy access to the malpractice information. I can't imagine a world in which anybody would think that it isn't reasonably practical to have that information. So I think with the stage we're at in the development, the broad language and the clear intent means I support the language as it is.
Thank you. Marta.
I concur with Tom. I think there needs to be clarity here. And then I just wanted, I'm sorry, I just wanted to ask a slightly different question, and as to what we're asked to be voting on right now. I believe Kevin added some points, but were they part of this section or were they a different section? Because I kind of got lost where Mimi was placing his edits.
So I think I can answer that last bit. Mimi made some notes during the discussion, but when Becky made a motion, she did not incorporate that particular input.
Great.
So the motion that we're voting on doesn't include those additions. After we adopt this, if we adopt it, if someone wants to make a specific motion, like I move we add to the list of questions X, we could certainly consider it, but we're going to sort of take Becky's proposal first, unless Becky is persuaded to take a friendly amendment.
I understand. Thank you for clarifying that. I just wanted to make sure, because where Mimi placed it in relation to the other items on the document, I was confused, but I get it now.
No, it's basically just notes Mimi has made that we're not voting on at this time.
Great. Thank you.
John. You're on mute, John.
Thank you. I just want to speak in favor of the way Becky has the motion currently and the wording currently set up. And I guess we'll push back on Tom's idea, because as I read this whole resolution, this is about the study piece of the sandbox. This is not about the regulatory side of the sandbox. And I think we need to allow for that and frankly not mix those two. If we're going to require data about consumer complaints and use that, for example, to put a provider in the red or the green or the yellow because there's too many complaints, that's a whole different mechanism and process than what I understand we're talking about here. And Becky, you can correct me if I'm wrong, but I understood this to be about what we're trying to study and learn from the sandbox more so than the control and regulation of the providers in it.
Which ties back to Crispin's point, because if the consumer complaints are going to be required by what we all vote on, perhaps as soon as this afternoon, then surely it will not be difficult for someone to study them because they are all required. Any other comments or questions? It looks like Tom has one.
Yeah, just briefly, I I think it's worse if this is the study and we're going to make this all optional. I mean, the point of this whole activity is to create an information flow for decision makers. So if the fourth bullet in that first bit is competence, we do need some information on that. We want to know if this helps resolve the knowledge gap. We want to know if these kinds of solutions are useful in comparison to, say, the court system's self-help centers that they've created. I mean, none of that should be optional, it seems to me. But I don't want to be obstructionist here, but I think making this sort of optional is a very dangerous thing to do.
All right. Before I call on Marta, I'm just going to make the observation that were Becky to decide to take out the words about extent reasonably possible, the verb address is vague enough. It doesn't really require definitively resolve. So one can address without definitively resolving where data is insufficient. But Marta, you're next.
I agree with Tom. I think the word choice is unclear, which makes it seem that it is an option. And I'm not comfortable with that because I think that is not what we're supposed to be doing here relative to legal services being delivered to consumers. And I'm really uncomfortable with that, the way that's worded. I would be much more comfortable if those words if the blue underlined comments came out of that statement.
Thank you. Dan.
I agree with both Tom and Martha. This should not be optional. I'm not sure I've heard a compelling explanation of what the downside is to making it explicit as part of this document.
Okay, Becky, you've had 3 requests for a friendly amendment to delete the language in blue. Would you like to delete it or to maintain it?
Oh, I embrace them. I embrace those requests.
All right, so
let's do it. Let's take it out. And I would also direct the members of the committee who are concerned about these issues to take a look at item D on today's agenda, where we will be discussing reporting, monitoring, and auditing as part of the regulatory function of the sandbox. I think many of the issues that you're raising will be important to raise later on this afternoon.
All right. Becky's motion got a second. I think it was from Toby. Toby, do you agree with her accepting of the friendly amendment?
Yes.
And is there anybody who still wants to comment before we take this to a vote? Dan, I see your hand raised. I can't tell if that's okay. That's vestigial. Then Mimi, I think you're on.
Okay. Marta Alkenbrock.
I'm sorry. So we are now voting on number 4 and what comes underneath it and not what Kevin had outlined in the blue.
Correct. That's exactly right. So
Mimi, could you please just scroll down because I don't see what those things are on my screen, please.
So the only change from the language in the memo as you all received it is the words "and discoverable" have been stricken. So you can ignore the blue stuff right now because we're not voting on that, Mimi.
Yeah, I know. She just wanted to see it, so I scrolled down.
Got it.
And now is not the time to, are we going to vote on the items which Kevin outlined?
Only if someone makes a motion after we voted on Becky's motion. So you or Kevin or anyone who wants to make sure and add that can certainly make such a motion, or we could on some other occasion, address the subject. But for now we have Becky's motion that we're asking people to vote on.
Approve.
Okay.
If we're back to, go ahead. Sorry.
Andrea Arruda.
Approve.
Mary Baldwin. Judge Wendy Chang.
Approve.
David Engstrom. Tom Green.
Yes.
Dan Grunfeld.
Yes.
Eric Helland.
Approve.
Kathy Huang.
Approved.
Micah Star Liberty. John Lund.
Approve.
Kevin Moore. Wendy Musell, Crispin Passmore,
Approve.
Lucy Rica,
Approve.
Toby Rothschild,
Approve.
Becky Sandifer,
Approve.
Jim Sandman,
Approve.
Patricia Scutiero,
Approve.
and Sasha Steinberger.
Approve.
Thank you.
So we've unanimously adopted that motion. And with that, are at least for now finished with this agenda item. But I just want to make something clear, which is that if Kevin Moore, who I believe is not on the call right now because he had to go somewhere midday, but if he comes back, or if anybody else who shares his desire to see something about the impact on courts being expressly addressed, wants to make a motion, we could still pick it up at the end of the day. We could return to this agenda item at the end of the day if someone offers a specific motion. Okay?
Thank you. Thank you. Just when he does come back, I would like to raise that, but I would like him to be here. So because it was his comments that led to those additions, I'd like him to be here to address any specific questions, but I would like that to happen, if not today, at another time, if he's not coming back today.
That would be great if you would communicate perhaps offline with him and think about how specifically you want to propose that we add something, just what is the specific question we're going to add, where are we going to add it, that sort of thing.
Yes.
But for now, I think we are finished with that agenda item. And so I know I advertised lunch was going to start a little bit later in the morning, but or in the afternoon, but it seems to me this is a really good, clear place to take a break and to come back, and to come back this afternoon then to start with the discussion of separation of powers, the memo that everybody has and I hope has read from Brady. I don't know that there's a lot we're going to be doing with that, but if people have a lot of questions or concerns and want to have a lot of discussion of it, we will. Otherwise, fairly quickly, we'll be moving then to the SAGE agenda item that follows that. So let's take a half-hour lunch break and come back at 12:35. Thanks, everybody.
Thank you.
Bye.
We're live.
Welcome back, everyone. I would like to start this afternoon session with a quick recap for those who missed the end of the morning. We did finish the discussion on agenda item 2B, except that we hope to revisit at the end of the afternoon at the request of Marta Alcombrock and perhaps also Kevin to consider some additional questions that might be added. But for now, we are going to march right into item C, which is the separation of powers analysis that Brady, I'd like to thank you and your team for creating that wonderful memo. Perhaps you could give us a brief summary of your primary findings, just to sort of remind everyone about what I hope they had a good chance to read over the course of the last weeks, and then we'll see if there is discussion that follows.
Sure, no problem. Hi, everybody. I'll try not to follow the memo exactly and sort of summarize it and give you a high-level way to think about it. To start with, the proposed sandbox contemplates regulating activity, including potential exemptions from currently existing rules and statutes, activity mainly that concerns the practice of law. And in this area, as the memo sets forth, the Supreme Court has primary authority, including the exclusive right to determine who can practice law. The legislature can also regulate in this area, but only to the extent that the legislature's regulations don't defeat or materially impair the judiciary's exercise of its primary authority. So, while the Supreme Court has invalidated the legislature's exercise of its secondary authority over the practice of law, in a few cases, those disputes are rare. I haven't found one less than 41 years old. And that's likely because the Supreme Court and the legislature have a shared understanding of their proper constitutional roles in these areas. Now, Even though the judiciary does have primary authority here over the practice of law, and even though this sandbox will most likely be focused largely, if not entirely, on practice of law activities, the State Bar has committed that a sandbox will not be established without legislative authorization, even if it's not constitutionally required. So just as a matter of practice, given the important issues at play here, we anticipate and have committed to only proceeding and only establishing a sandbox with legislative authorization. As I'll mention at the end, beyond authorizing the program, the State Bar anticipates that the legislature could shape and oversee the program in a number of other ways. Now, in addition to those, the primary focus on practice of law activities, the sandbox may also regulate, which might include permitting exemptions from existing laws and regulations in areas related to legal services that don't constitute the practice of law. One example of this would be the regulations statutes and regulations regulating lawyer referral services. That's not the practice of law. And so therefore, it's actually the legislature's sole authority to regulate those areas. To the extent that the sandbox would permit any sort of exemptions or modifications of those types of rules, the legislature's authorization would not only be would be actually constitutionally required, in addition to the fact that we're going to get it anyway. So that's sort of a background on the separation of powers issues as we see them affecting the sandbox, and because we anticipate getting authorization and buy-in from both branches of government and the governor, in fact, because the governor would be signing any legislation, the separation of powers problems, hopefully there will be none. Another issue that has arisen at some meetings is the question of whether delegation of decision-making power by the legislature or the court is permissible. To some extent, this sandbox regulator will exercise delegated power of the court, and to the extent that the regulator is authorized to grant exemptions to non-practice of law statutes or rules, like the ones I mentioned having to do with loyal referral services, the regulator might exercise delegated power of the legislature. Such delegation of power to a regulator is permitted so long as fundamental issues of policies are decided by the legislature or court, so long as the grant of authority is accompanied by safeguards, such as oversight to prevent its abuse, and so long as adequate directions for implementation are provided. So power can be delegated as long as there's some clear instructions and the big issues are decided by the legislature or the court, depending on whose power is being delegated. One way to meet these basic requirements would be for the authorizing rules of court and legislation that authorize and establish the sandbox to specify the rules and statutes that sandbox participants could be exempted from, as well as the criteria, the specific criteria under which those exemptions could be allowed. Now, Professor Sandman asked a question and made a very good point that not all of the sandbox's work will even fall under this delegation framework. For instance, the basic decision of whether to admit an entity or person to the sandbox will actually be made by the Supreme Court upon recommendation by the sandbox regulator. So there, no power is really delegated at all. However, to the extent that exemptions from non-practice of law activities that are within the legislature's domain are permitted, the sandbox would be exercising delegated power from the legislature, which it can do again, as long as the legislature decides to let it, as long as the legislature decides the big issues and provides safeguards and instructions. And the sandbox will also likely exercise some delegated authority from the Supreme Court. Not all decisions of the sandbox, presumably, would require Supreme Court action. For instance, the sandbox regulator will likely make decisions about reporting and which reports to accept and when to ask for more information. The regulator might make findings in its proactive regulation and sort of intermediate decisions of that sort that will take effect without Supreme Court action. This setup's not actually dissimilar to the State Bar's regulation of attorneys. With the State Bar and attorney discipline and admissions, the Supreme Court and only the Supreme Court can admit an attorney, disbar an attorney, or suspend an attorney for certain lengths of time but the state bar has delegated authority to make other decisions. It can impose other types of discipline, lesser discipline, without direct action by the Supreme Court. So to sum up sort of the point of gaining an understanding, a mutual understanding of these areas of the law, and to restate the most important point as I saw of the memo, what we anticipate is a sandbox with a scope and detailed guiding rules that will be approved by both the legislature and the court, and that is permissible, that structure, under principles of separation of powers and the delegation doctrine. And while the court would be the body to ultimately approve, reject, or modify sandbox regulator recommendations with respect to admission to the sandbox, it's anticipated that the legislature will be involved in oversight in a number of ways beyond simply authorizing the program. That could include, as part of authorization, identification of specific statutes that could be subject to exemption within the sandbox in the standards and safeguards under which such exemptions could be granted. Appointment of members to the sandbox regulators governing board, imposition of reporting requirements on the sandbox regulator that is reporting to the legislature. The legislature could conduct oversight hearings to the extent that the legislature is involved in funding the sandbox. It would obviously have that lever of power, as well as the decisions whether to extend or sunset the sandbox. Additionally, the legislature ultimately may choose to adopt or reject some of the reforms or modifications piloted in the sandbox. And I think we repeated ourselves, any reauthorization or extension. So, the point of this memo was to address certain questions that have come up multiple times during our previous discussions, and hopefully, I don't want to say put those to rest, but explain them in a way that hopefully we can all be comfortable with these issues as we move forward. And with that, I will open to questions.
Thank you very much, Brady, for that excellent summary of your excellent memo. Are there questions for Brady? Are there discussion points anyone wants to make on this topic? I see Tom has one.
Yeah, just a question more than anything else. This was an amazing memo, but to you, Brady, is there anything in here that the legislature or the Supreme Court is going to see as surprising? I mean, if I were a member of the legislative staff and I read the Supreme Court as primary, and this seems like the Supreme Court is only suggesting that the legislature is getting involved as a matter of grace. That may be an overreading of the memo, but is there anything here that's going to be a lightning rod for our friends in the Assembly and the Senate?
I don't think so.
Okay, cool.
Other questions for Brady or comments? Okay. Mary, do you want to make a comment or proposal? You're on mute.
Yeah, thank you. Sorry about that. Yeah, I'd like to just, I guess, go ahead and make a resolution, which is basically similar to what's in the memo already. And yeah, so the working group recommends the sandbox shall be established only if authorized by both the Supreme Court and the legislature. So this just articulates and gives room for a vote on a principle that I think we've long held and is reflected in the memo.
Okay, thank you. It is indeed. Are there questions, comments, discussion on this before we go to a vote?
We need a second.
I'll second it.
Toby has seconded it. And hearing no discussion, Mary, your hand is still raised. Did you?
Sorry, no, done.
Okay.
Laura.
So Mimi, please call the roll.
Marta Alkenbrock.
Yes.
Andrea Arruda.
Abstain.
Mary Baldwin.
Approve.
Judge Wendy Chang.
Yes.
David Engstrom. Tom Green.
Yes.
Dan Grunfeld,
Yes.
Eric Helland,
Yes.
Kathy Huang,
Approved.
Micah Star Liberty, John Lund,
Approved.
Kevin Moore,
Yes.
Wendy Musell, Crispin Passmore,
Yes.
Lucy Rika,
Approved.
Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman, Patricia Scutiero,
Yes.
and Sasha Steinberger.
Yes.
Thank you.
All right, thank you all. With that, I believe we're ready to move to the SAGE agenda item 2D. And shall I call on Bridget to present this memo that I hope everyone's had a chance to read, and not just in the form it came around in a timely way last week, but in the expanded and improved version that came around last night. Bridget, you want to walk us through on an abbreviated basis?
Sure. So first of all, thanks to so many people that helped me with little pieces of this. Basically, this is an attempt to take that long list of tools that we've been talking about for a couple meetings and really kind of combine them into a recommendation and really something that can form the basis of what will ultimately end up in our report and the working group's report with respect to the proactive regulation, and just really the nuts and bolts of how the regulation would work in the sandbox. And so what we've done is we've provided appendices that will are meant to be illustrations of what, putting a little bit more meat on the bones, giving people ideas of how these different recommended tools can work, but not necessarily something that we need to go through and approve every single word of, more of just an example of what might a risk assessment look like, how does that actually function, and being able to look at that in the appendix that Eric Helland helped us put together, along with, examples of this is a potential entity and here's how we would look at that, based on the risk, and here's where we would, where they might fall. And we can definitely have discussions about the appendices themselves and whether you have questions, and this would be an opportunity to, kind of flesh out some questions or things that you think need to be changed and clarified. And then we can also put that into the final report, and you'll have a chance to comment on the final report too. So I just wanted to give everyone a sense before I kind of go into the details of what we're hoping to achieve with this memo, which is really a recommendation that we're approving the minimum requirements, and as we've talked about the structure of how the regulatory sandbox will work and the proactive regulatory tools that the regulator will use. And then understand that we can work on some of the more details about the suggested examples of how that might work that will end up in the report. So the way that I've grouped these are the risk assessment. We've talked about this a lot. This would be just a way when somebody is entering the sandbox for the regulator to determine what level of risk that is going to be assigned to the entity based on their service model, and also based on the types of services that they're trying to offer. And then, as we've talked about at prior meetings, it would be, the regulator would have the ability, or we would recommend that the regulator would have the ability to adjust that based on, the stakes of what's happening, et cetera, and this level of sophistication to the consumer. So it would still be a detailed or a very specific assessment as to each entity, but at least the risk assessment tool that we put together, that Eric helped put together in the appendix, would be an example of just a starting point for how you would start to assess the risk. And then the second part, number 2, is about the detailed authorization orders. And so what we did with Appendix 2 is provide an example. And I think once we get into discussion, we may want to add some things to that example, but it's just meant to give you all a sense of how, and this is based off of an example from Utah, but just how we can be very clear in the authorization order to say, here's what is being authorized, here's what this entity is being authorized to do. These are the specific practice areas. If there's non-lawyers, here's what they're allowed to do. Here's how they will be supervised in the sandbox. And you can just see from the example that we put in Appendix 2, the way that that might happen. Number 3 talks about regular reporting and monitoring, including audits. And so we have some examples there of the types of data that might be collected, the format, the frequency based on risk. And we included a little example of an audit form. So just to kind of show like how audits might be used in the sandbox to ensure that there's quality control. And then we have required consumer disclosures. And then this is where I do want to invite Crispin. When I'm just trying to think about the right timing, but we do have an example in number 4 on consumer disclosures about badges. And he dropped me an email today to let me know that it's really more sophisticated than I described in this memo, and I can amend this for the report, obviously, but the way that they use it, the SRA uses the digital badge. So I thought, let me just pause here and just have Crispin explain that a little bit more to you all before we dive into the details of the rest of it.
Okay, thanks, Bridget. I can do that. So the SRA, the regulator for solicitors firms, law firms in England and Wales, requires all law firms to have a digital badge on their website if they have a website. It's more than just putting a logo onto your website. So it's an interactive online badge that updates with the date in real time so that you know that it's a real one. And when you click on it, it takes you to an SRA website that confirms that the website you've been looking at of the law firm is a real law firm that's actually regulated and is verified. And it also provides you with some consumer information. So that page provides you with information about insurance, compensation funds in case things go wrong, right to complain, right to go to an ombudsman. You can put any information you want onto that page, and then you click back to return to the law firm's website. The reason it's used for all law firms is that there was a spate of scamming attempts of crooks trying to replicate law firms' websites to attract people and attract vulnerable consumers particularly, but actually not so vulnerable consumers as well, and use the law firm's name and use the law firm's website to take money off people. So being able to check that the website is real was an important step for building confidence in law firms. Once we built it, we realized we could give consumers extra information via that as well. It's very cheap to run. It's simple code to drop into a firm's website, and you can update the information as you want. It's really amenable to something like a sandbox where you could explain to people, you've come to somebody that's within the sandbox. This is what it means. This is the consumer protection. This is the way they're regulated. And this is different to going to a regular attorney. So you could provide that information as well. So it's a really great way to connect with the actual consumers in real time, the way that the service is being used. Very cheap to deploy and very easy to deploy as well. Hope that helps, Bridget.
That is great, because as I was working on this memo, we were trying to think about information that we thought would be helpful for the consumer to know, but I was really limited in my thinking to like, well, we can't put all that on this badge. So I didn't realize that you can actually click on it and it would go somewhere. I think that makes a lot of sense. So I can definitely refine the memo to explain that more thoroughly, but I appreciate you giving that explanation to the group. And then I just put down some, again, in the appendix, it has some example language of what types of disclosures might be required depending on the service model that's being ultimately admitted, whether there's non-lawyers providing services, et cetera. We also borrowed some suggested language from what the paraprofessional working group has been doing with respect to free legal services, letting people know that, you may qualify for free legal services, might be something that we might want to require. And then finally, the last little grouping has to do with additional security measures. So this one, we don't have an appendix, but it's just something we can talk about and are specific tools that the regulator could utilize for example, having security claims for, you could have a bond, for example. These are some things that we still need to flesh out as a working group, like whether we would require insurance or whether we require a bond, that type of thing. Secret shopper programs in appropriate circumstances, consumer complaint mechanisms, how those will be processed, and then customer satisfaction surveys. So that's just my broad overview of what's contained in here and just kind of what we're trying to accomplish by putting this out. And then I just thought we could open it up for specific questions that you have, and then I can turn to Mary as far as putting it together for the recommendation.
So are there
There's a lot here.
specific questions for Bridget before we? Okay, hearing no questions. Mary, did you have a motion?
Yeah, this is based mostly on what's in the materials, but I refined it slightly. So this would be that the working group recommends that the regulator implements policies and procedures to minimize the risk of harm to consumers through proactive risk-based regulation that uses regulatory tools, including but not limited to the tools described and illustrated in the memo that we're looking at right now. And then this is the title of the memo. The alternative was to list out all of the contents of the memo, which, thinking about it just seemed too burdensome. And I actually would not include this bottom language, Mimi, that each of the proactive components, I would not include that in the resolution.
All right, we have a resolution from Mary. Is there anyone who wishes to second it?
I'm happy to second it, Chair.
Crispin seconds it. Thank you. So now is a good opportunity to engage in more fulsome discussion of what you see here. Do people think we've got the right list of regulatory tools? Do you think that the appendices accurately portray what you would like us to be saying about for example, what a sample order would look like, or what a risk assessment matrix would look like? Okay, Mary, and then Kevin.
Yeah, I'll just, thanks. I'll just say that, we've been working with the sort of list of tools for a little while in the SAGE committee. And I think this memo does a really great job of providing some meat on the bones and giving some, fleshing out some ideas that really had been very skeletal before. And I think by looking at this, and especially at the appendices, can give, a level of certainly just tangibility to some of the things that we've been talking about. And I think these illustrate the protection that would be provided to consumers through both the oversight measures as well as the disclosure requirements. And I think it's very helpful. I guess I would note that, the appendices are intended to be illustrations. And, I think we could edit them and we might want to refine them. And as we roll along, we might want to make some changes to them. But this would allow us to do that as part of the report. We could make some changes to it and then approve those changes as part of the report that we're doing. For example, in the appendix, I can't remember if it's 2 or 3, the sample order, one of the provisions that our memo describes as these orders would accomplish would be to list any rules or statutes that are being waived for a specific applicant. And I don't think this sample order does that, for example, but that's something that we can, this is a sample, it's intended to illustrate, an example. So it doesn't have to be, this isn't intended to be a template that would be, used in all instances. But we could modify that as an example moving forward if we wanted to.
Thank you. Kevin.
Yeah, the only point I wanted to make is in response to your question, do you think we covered pretty much the field with those things? I just look at the words including but not limited to. And so we don't have to, in this resolution, cover everything, because as we discuss it further, as we perhaps get feedback from Utah and how their regulatory sandbox is working. We can add new things. So I'm fine with it as it's stated.
Okay, thank you. Tom.
Yeah, I've got a few comments, although if this is just sort of suggestive, but let me just raise a few. On Appendix 1, risk assessment, I think this needs a tad bit of work because apparently the lowest risk is lawyer employed or managed by a non-lawyer, which does not strike me as what we actually had in mind. So I think we need to, it's the bottom one. Yeah.
Actually,
So,
that's lawyer-owned
lawyer
and
employed
provided by a lawyer.
That's not what it says on mine.
We
actually refined it, yeah, based on, yeah, go ahead.
Let's make sure we're all looking at the same thing. And this is an email. We did change it as recently as yesterday. And so
okay.
Mimi circulated it. Yeah. So Mimi circulated an email last night at 5:51 p.m. to everybody in the working group. And I think it was also posted to the public at either right before or right after.
Okay,
and
so let me make a different point, which is I find the owned notion here. I mean, I've adverted to this in earlier conversations, but I'm not sure what owned means. So if this is a corporation, law co, and the shareholders are lawyers, I'm not sure that, rules 5.1 and 5.3 apply. Maybe somebody can tell me that is how it would work, but owned is not clearly the same to me anyway, as lawyers are responsible for making sure that this entity operates within the usual rules applicable to law firms. So I think that if that kind of an entity where 5.1, 5.3 apply, that's probably the lowest risk possible. But owned is at the very least ambiguous. So that would be one point. And then I'm not sure, this is on Appendix 3, page 1, under 1, annual reporting. It's not quite clear to me what controlling interests mean, 51%. I mean, it's just kind of ambiguous from my perspective.
Sorry, you're looking at Appendix 3.
Appendix 3A sub 1, annual entity reporting.
Got it. So there's a single sentence there. It reads, Sandbox authorized entities will have certain limited annual reporting / certification requirements, confirming the status of their controlling and financing persons. And what is your concern or suggested improvement?
I think I'd strike of those with controlling interests, or at least define what that means. I mean, is this only a shareholder with 51%, or, I mean,
Got it. So this might be something that is more easily clarified in the reporting and monitoring memo once we have finished in the scope discussion as to what are the requirements for initial disclosure and approval as to who owns what. And because I think the point here is on an annual basis, we're going to want to recheck that information and make sure we still have the right owners accounted for, the right executives accounted for, the right person has gone through the, through the approval process and so on. So yes, I think that it's likely that language will need some improving in the fullness of time, probably not possible today.
Yeah, no, that's fine. I just wanted to flag a few things. And then
yes, good.
With respect to sub B, also in Appendix 3, it's on page 3, compliance auditing. It looks like this seems to be saying it's the moderate versus high. First 40 completed services. I'm not sure we want to tell people we're going to just do the first X number. I think as a matter of regulatory clarity, it's good to just do this on a random basis, so they don't, spiff themselves up for the first whatevers and then, it falls off later. I mean, there's some other tools in here, but I think that some indication that this would be not an obvious specific number at the beginning, which would allow and facilitate gaming at this point. And then above that, in the prefatory paragraph, we're supposed to be testing legal quality and accuracy of services provided by non-lawyer humans or software. I'm not sure. I think I'd consider dropping by non-lawyer humans or software, just because.
I'm sorry, I've lost where you are, Tom. Would you just?
I'm in B.
So still
and,
Appendix 3, Section B.
Yeah, the prefatory paragraph, starting at line 3 and going into line 2 and going into 3. It says, the purpose of the audits is to test for the legal quality and accuracy of services provided by non-lawyer humans or software. I mean, we might be in a situation, for example, where there's a span of control issue. We've got a lawyer in charge, but he or she is supervising 50 non-lawyers. That would raise issues in terms of probable quality. So I think I would not limit this to non-lawyer humans or software.
Got it.
But those were just really quick hits.
So I appreciate that. I had another thought with regard to this entire appendix, which is that to some extent, what this appendix adds beyond what is elsewhere in the memo is a level of specificity that might be more than we want to or need to provide. Because, the regulator is going to have to make some of its own decisions. And we don't want to be micromanaging or anticipating or specifying, the outcome of all of those decisions. We need to make recommendations that will enable the legislature and the Supreme Court to decide if this is the, direction they want to go down, making the high-level decisions, as we heard from Brady's memo, but not making every single tactical choice. So I have some of the concerns that you raised specifically about this appendix, but also just that larger concern about whether we want to include that appendix, whether we want to go to the trouble of refining and including it, or whether we want to say, hey, that's more than we need to know and ought to be saying.
Yeah, just one guy's view on that. That is a very important strategic question, and I can see that cutting both ways. If it doesn't look like we covered the obvious bases, then we'll get criticized. If we provide too much detail, we also get criticized. I think I come down on the slightly more detailed side of this, but I can see us landing in either spot, Justice Tucker.
Well, good. It's an issue I wanted to flag for discussion to the extent we're talking about this appendix. Sasha.
Hi. I just had kind of a general thought, which is maybe obvious, and I'm not recommending any changes to this. I think all the proactive recommendations seem good, but just that, in our work, we work mostly with low-income communities who don't have access to lawyers, and often are dealing with clients who can't get help from their lawyers they do have and are not getting the services they've paid for and aren't going to take the affirmative steps to report lawyers, and just sort of noting that there is, insofar as this has some implied judgment around lawyers being more ethical without proactive measures, I just want to call out that is not necessarily the public's experience. So I think that the proactive measures are great, and also just want to, as a room of mostly lawyers, reflect back that that's not the public's experience necessarily.
Thank you, Sasha, for bringing that in. John has a comment or question.
Hi, yeah, I'm sorry, I'm driving at the moment, so I apologize if the communication's bad. Can you hear me okay?
Barely.
Okay. I just want to, on this note about the appendices, I think the operative term there is that they're illustrative. And I hope they're helpful in that setting. Yes. But really nothing more than that. And certainly the regulator is going to need the flexibility at the end. So I guess I'm comfortable with the way it's worded. I think we were being responsive to some extent to Leah's point about flushing things out for the regulator down the road and not having a round 3 where these issues get worked up all over again. So that's my comment.
Thank you. I'm not seeing any other hands raised right now. But can I ask if we could have shown on the screen the 4 examples and then the chart right below them? Okay, so we've got these 4 examples, and then I guess that there's not enough room on the screen for everything. So let's look at the chart. All right, can people see that either on the screen or because you have it convenient in a document that you opened from last night's email? Because one of Tom's points is like the phrasing of one or more of the things along the left-hand side of this chart, the vertical axis. So the basic framework here is that we're trying to capture, I guess, 2 of the 3 vectors that we've said are significant in terms of risk. Nature of the service along the horizontal axis being one, how the service is provided along the vertical axis. The one that isn't expressly captured here because it's a 2-dimensional piece of paper is the stakes at issue. Are we talking about deporting somebody or something less consequential? But if we could focus for a minute on the vertical axis. So this is an attempt to say, roughly speaking, that some service models are riskier than others. I don't know, Mimi, if you can move the box so we can read there we go, perfect, thank you. So right now we have at the bottom the thing that is conventional, lawyer-owned firm and services provided by a lawyer. In other words, what we have today without going in the sandbox. And then we have at the very top, a non-lawyer provider without lawyer involvement. I think it's pretty easy to see why one of those is lowest risk and one of those is highest risk. And then we put 2 things in the middle, lawyer employed primarily by non-lawyers and less than 50% non-lawyer ownership. I thought we had a different. Okay, well, in any event, that's what we got here now. And so the question is, are there ways that we should change the way these are characterized? We can't necessarily, we want to maintain the fact that we've got a scale that starts with the least risky and goes up to the most risky. And sometimes it's hard to characterize in the abstract where the risk level lies, but I think there's some room for refinement, and Tom has already asked for some improvement in at least one of these descriptions, although I'm not sure, Tom, what specific edit you had in mind. John, do you still have a question or comment?
No, I'm sorry, I'll take my hand out.
Okay, Neil has a question or comment.
Yeah, I just wanted to clarify. So the bottom part of that risk chart, lawyer-owned firm and services provided by a lawyer, and then the 4 different types of legal services. Are we saying that going along those boxes there are not within the sandbox?
No. If I understand, are you looking at the vertical axis or the horizontal one?
No, I'm looking at the lowest level of risk, lawyer-owned firm and services provided by a lawyer.
On the vertical axis.
Yeah.
So that is not in the sandbox, but it is the least risky.
Right, yeah. So I just wanted to clarify that. So But
Yeah.
I also agree with the idea of incorporating criticality of the legal service, right? Being sought if it's immigration or housing.
So we have attempted to incorporate that by speaking it rather than by visually depicting it because of the difficulty of coming up with what an axis would look like, and because of the difficulty of having 3 axes. Eric, I think you may have done some work on this, and I think you have some helpful suggestions.
I did, or well, I don't know if they're helpful, but I have some suggestions. So I guess one thing, and I think this was Sasha's point as well. I think we want to be clear that part of this is the risk assessment within the sandbox. You know, we have the status quo. The initial version I had sort of put together, I didn't actually put in the bottom category, thinking it would be outside the sandbox, so I would sort of include it. But I think it's really useful to have it as a baseline, because whatever we call this, it clarifies the idea that we're moving away from the traditional provision of legal services, and the farther away that goes, the more scrutiny. So one suggestion might be, do we want to change this higher risk to higher scrutiny? This is a risk assessment, but to Sasha's point, it does sort of imply that we're making a value judgment that sort of lawyer ownership and lawyer provided service is inherently less risky. And I think this was really just motivated by, that's what the sandbox is doing, is it's assessing deviations from kind of the current model. I don't know if that makes any sense, but that was kind of what was motivating that axis, I think. Or is that kind of what we were after?
Yes, and I think your point is well taken about the risk. I feel like we had this conversation early on in the SAGE subcommittee about is lawyer involvement really the right measure of risk to begin with? But I think if I recall right, that the subcommittee ultimately came around to deciding yes for precisely the reasons that you're describing, which is what we're trying to test in the sandbox is this deviation from the existing model, right? So I mean, I get that literally the word risk sounds kind of offensive, but I think it makes sense for the overall way that this is going to be functioning, because we're trying to test whether or not that really is going to cause harm, right? And so I don't know if that's answering your question, but that is the way that we have set it up now. And I also just wanted to point out just for a minute that what's here in this appendix, again, is just kind of illustrative, and it's not like we're trying to nail down the specific ranges of services that will be permitted or not, or the types of models that will be permitted or not. In fact, it's something that I think, first of all, we have to decide, as the scope subcommittee has to come forward with something, we have to decide about the scope anyway. But besides that, I do think it's something that, based on Utah, and Lucy, you might have some insight, or John, about this too, but I think, who knows what kinds of things are going to end up being what people are going to apply for. And so you may have to add lines somewhere, and you have to be a little bit flexible with this as it's going, because maybe it's something that we haven't really thought about yet as a potential service model, and how will that be handled as well. So I just wanted to throw some of those out there, that not to get bogged down by the titles here, I just wanted to make sure it was clear that we're not trying to nail us down here as far as what types of services are going to be offered.
I want to also point out that the vertical axis was simplified at my request, but I think we may have gotten it a little too simple, because it looks like we dropped off non-lawyer provider with direct lawyer involvement, so that we only have non-lawyer provider without, I would add the word direct lawyer involvement at that highest end. And so I think we probably want non-lawyer provider both with or without lawyer involvement. And I don't know that we can do a real-time edit, but I would suggest that we add back non-lawyer provider with direct lawyer involvement. And then as to where it goes, I don't know, perhaps smack in the middle between less than 50% non-lawyer ownership and lawyer employed primarily by non-lawyers. Crispin has a question or comment.
Thanks, Chair. I think I support where this is at the moment as an illustrative document, and I think it's right to include that bottom layer of lawyer-owned firm and services provided by a lawyer as of itself lower risk, because that is what the regulatory system at the moment has decided. Whether any of us think that's right or not, or whether experience through the sandbox will tell us to change it, I think that at the moment we have decided that it's lower risk, and we're putting controls around things through a sandbox that we think are higher risk. And then the various points on the scale, they're sliding scales. They're not only 4 points or now 5, they are just sliding scales. And over the life of the sandbox, we will add things to it, and we might change our view on the relative risk of things on that scale at the moment as we build our evidence. To me, that's the whole point of the sandbox. So this is really just a good framework to enter into the process, and that we'll learn as we go.
Thank you, Lucy.
Yeah, I totally agree. I mean, I think, obviously this is sort of the framework that we've laid out in Utah. And I think one thing that we really learned a lot is that, allowing that flexibility and that discretion to be responsive when new situations come up, that's the whole point of this exercise. And so giving the principle, that this is a risk-based approach to regulation, this is in concept what this looks like. In reality, on the ground, what's going to come before the regulator is going to come, and we very well may not have thought of it. And that should be okay, because the structure that we're setting up is that the regulator then applies the principle, goes to the court to get approval, and then, moves forward. So I think, yeah, there's a lot of language finessing, but I don't think we need to do that now. Yeah, and the other thing I was going to say real quick is that obviously entities will offer services across many of these models. And what we've done in Utah is waterfall them up. So, if someone's taking outside investment, but they're also having a non-lawyer provision, tier of service, they are at the higher risk level, even, regardless. So just to be clear, like there's a lot of things that come up that cannot be ascertained in advance.
Well, we have a motion. Tom has a question or comment.
Yeah, I think just a couple of thoughts. The example 1, low risk, is at the second level of riskiness in this thing. I think you might want to push that down to 10. And I think conceptually, I think the idea I was trying to get at with the bottom one as it's currently framed, I'd probably think about something like lawyer-owned firm and services provided by a lawyer subject to current rules and statutes or something. I mean, that gets at the 5.1, 5.3 issue and the conflicts issue. So that's probably the least risky, because insofar as we assume that this is, the current law firm kind of structure is the least risky. But that was just the idea, that it would be subject to current ethical rules and statutes.
We could just put a little parens, current rules, because that kind of captures it all. Okay, so we might need to move some of these example 1, 2, 3, 4 bullet points around a little now that we've done a little refining of what the vertical axis is going to look like. Other questions or concerns about this appendix or about the other appendix?
Go back for a second. So you think this should be lower?
I think so, yeah.
I think what they were trying to do was say that in this model where it's less than 50% ownership and they're doing this, it's a low risk. It's not really about placement.
Oh, I see what you're saying. It's the matrix. Okay, yeah, no, that makes sense.
Matrix. I mean, it would look different if we put it in a table, I guess, but what it's not where it's placed isn't telling you what the risk is per se. It's more based on the entity's composition versus the services are providing, and not based really on risk.
Yeah, no, that point's well taken. Thank you. That's helpful.
Okay. Other questions or concerns? Well, I thought that there would be more discussion, but since there isn't, why don't we go directly to a vote? So this is the proposed recommendation.
I'm sorry, can I interpose something?
Of course.
We've now made some edits to some of the appendices, and I don't know to the extent those are going to be accepted or not. And it's kind of hard to read it on Mimi's screen as she's typing in, which is great. And thank you, Mimi, for your real-time edits. But is that what we have right now? Is that the motion that we're ruling on now? Is that the appendix as attached that we just edited is part of the motion? Is that what we're working on? And it's including but not limited to, and it's going to evolve over time?
That's a very good question. So let me ask the motion maker and her second. Would it be appropriate to say, after we name the memo, just put in parentheses as amended, with the idea being that we've just made some amendments during the meeting?
That's a good question. And to echo Marta's point, I think it might be helpful to walk through those edits, because I agree with her. This unspools in real time, and I'm not sure where we ended up. So that's a really good point. I think we should walk through those edits. And I think we could just say, yeah, as amended.
Okay. So now let's go through what those amendments are. And Mimi, you control the screen, so I have to, I think, follow you. But I don't think there are any amendments on the memo itself. They're only on the appendices, right?
And I don't know that she captured all the edits on the table as they were going in real time.
Yeah, that's what I want to, if there's no amendment to the memo itself, I want to go straight to Appendix 1, which I think is this table. And so on the left margin, we have a blank yellow, and we're going to add there non-lawyer provider with direct lawyer involvement. And then I also asked that at the very top of the screen where it's exactly there, that we add the word direct. So it's without direct lawyer involvement. So we got with and without direct lawyer involvement. So we're just adding the word direct into this top one.
Right. That's why I wrote revise.
Yeah, no, it's perfect. And then on the bottom one, we're putting in parentheses at the end, current rules.
Oh,
So just fewer words here. Okay, and that's going to be in parentheses at the end of that item. And then this is going to be really small, but I would also ask that we sort of resize the left margin now that I don't want to do that real time. I don't think we have to vote on that, but just once we've got a final product in the memo, that I think that would be part of it. And that there may also be some moving of these example 1, 2, 3, 4 data points once we've resized.
Was there a revision instead of using the word higher risk, it was something else?
That was suggested, but I think not pursued.
Okay.
But you can tell me if I'm wrong, Mary.
No, I don't. I approve these the changes that we have on the screen here.
Okay.
And also a reminder, sorry, real quick, is just that, we'll add these in, but then everyone will have a chance to review the final report. And if there are more refinements that need to be made at that time, once we have all this discussion, this is not like the last time we'll ever be looking at or refining these appendices. So I just wanted to give you all that comfort too.
So that's helpful. And I think this ends the edits people have made to Exhibit 1, except Crispin and Tom both have their hands raised. Is it to Exhibit 1 that you want to speak?
It is. I just want to stress, Chair, that my understanding is we're approving these subject to continual amendment until we get to the final report. So I'm not sure we need to, amend all of the detail, because I'm sure that Bridget and the team will be making all sorts of amendments as we go through the next few months listening to the debate.
Thank you. I think that's right. Tom?
Yeah, I just wanted to confirm that what Crispin just said is correct. And then just one note in the first page of the memo, this traditional regulation uses primarily reactive tools to regulate licensees. I mean, for all of those of us who took the California bar exam and went to law school, that we went through a process before there was ever a complaint, as far as I know. So it's just something that should be corrected over the passage of time.
Supervise rather than regulate is probably the effective word.
Yeah, that was meant to reflect the complaint based, it's like reactive if somebody files a complaint. And
yeah, sure.
Yeah.
All right, so supervise instead of regulate is a good suggestion for that, unless Mary or her second disagrees.
No, that's fine.
Okay, so I think that takes us through Appendix 1. I know there were some changes to Appendix 3, but I don't think there were any to Appendix 2, this draft order, right?
In my notes, I just have that possibly we may want to add at a later date waivable rules in a sample authorization order.
Okay, so that will bring us back to the subject to further refinement as we go along point, which I want to circle back to after we finish. Okay, so then moving along to number 3. I think number 3, there were some concerns that maybe weren't fully
Yeah, I think that was me, and it's just controlling interest isn't defined here. So maybe we can just put a pin in this one, and maybe Bridget and crew can give us some clarity there.
Okay. So I think there are several points on Appendix 3 that so this first one, we're going to need to refine on an iterative basis, we know. And then if you keep going through, data reporting requirement. Okay, so here was another thing. I think someone suggested we just take those words out. We might be able to do that right now. I don't know. Do you have a view, Mary?
That seems fine to me.
All right, so let's take those words out. And then we had a suggestion that the first 20 and the first 40 were not helpful. But we didn't have a specific proposed change, so maybe we just want to indicate that's an area we'd like to see further change.
If you were worried that the system was going to be gained, couldn't we just strike the word first and it could be 20 completed services audited at random or something?
Yeah, that would be helpful. Or you could just strike everything after regulator down to the thing down at the end that ends moderate high. Well, no. I think your strike that. Your solution would work for me.
So we wouldn't do the first 20. You just don't know which 20 we're auditing, and that would probably be. It's more random that way. And that might.
And I don't know that we want to say 20 is the right. I'm not comfortable really saying a number, frankly.
We could just make it XX for now, or a undetermined number of completed services. I don't know. I think what we were trying to do is differentiate that moderately risky models would have less audits done, whereas high risk models would have more audits done.
Right.
Yeah.
Well, I don't think we need to come up, unless somebody feels we need to nail that down. I don't know that we need to do that right now, but I do think we need to have some kind of change there. Marta.
I'm sorry, I just have a question here. Is this suggesting that the audits are only going to take place after a certain period of time, and if they complete the audits, that's it? Or, so in other words, one and done? Or is it going to be an auditing process that continues through the length of their time within the sandbox?
My thought is that we probably want to get rid of these bullet points and leave it to leave exactly how many for exactly which applications to be something decided later by the regulator, rather than to try to specify 20
Well, I would,
or which 20 or which 40. And I would, because I don't think we want just one and done.
right, I don't either. I would be in
Yeah.
favor of a one and done, and this is kind of what it suggests. And I would think that the language would be something about, auditing on a on an ongoing basis throughout their time within the their licenses approved, and they're operating within the sandbox. I mean, like, and it's up to the audit, it's up to the sandbox regulator to determine when those audits are going to take place. That I would be much more comfortable with, because this is the way this reads right now. It's almost like it's a one and done.
I wonder if instead of these bullets, we could just have audits will be conducted more frequently for higher risk models, and just leave it at that.
That would simplify it and I would be much more comfortable with something like that.
Yeah.
Okay, we have some, Mary and Seconder can think about that. In the meantime, we have hands raised from Bridget and from Lucy.
I just want to jump in just to be responsive to Marta, and this is where it gets tricky, and I found myself going back and forth as I was putting these together. So in the memo, what I was meaning for people to really be voting on really is what's in the memo, which says, and you don't have to I'll just read it. It just says, in addition to data collection analysis, the regulator must also conduct regular audits to test for legal quality and accuracy of the services provided. And that's where it says by non-lawyers or software, because that's what I had written here in the memo, kind of based on different models that I'd been researching, was that, data collection would be maybe for the low risk. If you're moderate risk because you had non-lawyers or software providing some of the services, then you would be subject to additional level of proactive regulation in the form of these audits. And then the audits, but this does not specify, as the appendix does, which is more illustrative, just to give an example of what like a manual might look like, that is telling people, telling the entity, this is what you're going to be subject to. The part in the memo itself is more broad, as you're suggesting, which just says, the frequency and detail of the audits may be adjusted based on the level of risk. And I think that's what the concept and the principle that we're trying to vote on and recommend. And then the appendix is meant to be an illustration of, what an entity might receive once they're admitted into the sandbox, to say, okay, this is how you're going to be monitored within the sandbox. And this is an example of how that might look. So I get that it gets kind of confusing, and I think we should definitely clarify that. I just wanted to point out that difference.
Thank you, Lucy.
Yeah, I think the paragraph that we're looking at right now, I think it hits the right kind of balancing act. I think the only thing I just want to, keeping in mind the objective of the sandbox and the objective that these audits are meant to further, it's to ensure a kind of, essential quality and accuracy of legal services, right? So in some cases, if other data indicates that, and if it's a higher risk entity, then multiple audits are probably appropriate, right? But not always. Maybe one audit, if there's no other indicators of consumer harm and the service is relatively simple, then maybe it's fine with one audit. And I would caution, so I don't want to put in place something that requires the sandbox the regulator to always conduct multiple audits regardless of its individual determination of necessity, because they're difficult. They're one of the most, we just finished our first round in Utah. They are difficult and they are expensive. And so I just want to put that cautionary note there.
But I'm confused, Lucy, because I think you said you don't want to require multiple ones, but then I think you also said you like the current language, which talks about 20 or 40.
So I like the current language in this paragraph here. I think we should leave the detail.
Oh, in the one that we're looking at on the screen.
Yeah.
Okay, so you're not endorsing the language in the appendix where we get more specific.
I just don't think we need it at this stage. I mean, it's similar to what we're doing in Utah, but it's, we developed that in our innovation office manual, which was like the regulator doing their job, and then it was approved by the court. So like, yeah, but I think this overview, again, sets out the principle that the regulator then must follow very well.
Okay, Bridget.
I think my hand was still up. I forgot to lower it, but I guess I would just say maybe the appendix, this maybe gets back to your point, Justice Tucker, about the appendix on this one being more confusing than it's worth, because I think I was thinking the appendix would be more like the manual that you would receive when you, as an entity, like here's an example of what it would look like, but maybe that example is just making it more confusing. I'm not, that's definitely not the intent, but I do want to just point the difference out there.
I think Appendix 1, 2, and 4 are useful, but my own personal view is I wouldn't mind saying goodbye to this one. But that may not be the view of the rest of the group. Anybody want to express a view on that subject or otherwise? Well, we're still, because I think Marta correctly said, hey, let's be clear on what exactly we are endorsing, since this is at least a starting point, even if it's subject to change for the final report.
Yeah, if I can. 4 is the one that needs work, and eliminating it for this round would probably not be a big loss, I think.
You said 4, or so not the one we're talking about now?
3, excuse me. Yeah.
3.
So 1, 2, and 4.
Okay. So in other words, Tom, you're suggesting as a friendly amendment that Mary consider saying that we're adopting all of this except at this time Appendix 3.
Yeah, I think that would be a proposal. We can always ask for more scrivening around this. But I think for us to do this today is just going to take a lot of time.
Yeah, okay. Mary, Marta has a question or comment.
Yes. Well, going back to the paragraph earlier that Bridget was reading in the body of the memo, which yes, this sentence that I have trouble with here is, and I think Tom brought this up in his comments earlier when we were looking, I think at the graph, or at some portion of the appendix where it's the last part of that first sentence that says services provided by non-lawyers or software. I think that sentence could end with services, period. And then with respect to Appendix 3, I don't know that we need to wash the, throw the baby out with bathwater, because I think the problem is more with subsection B of Appendix 3. So perhaps that's the section that needs to come out, or we send this back to scope and we ask that, excuse me, Sage, yes, Sage, sorry, I get them all confused. And they revise and think about it and make another recommendation back to the entire working group, because this is a big question and we're kind of doing it on the fly, and I don't know if that's appropriate at this point in time.
So I guess one possibility would be so we leave everything else in Appendix 3, but then in compliance auditing under B, we could just delete everything from after regulator in that first paragraph. So audits will be conducted as follows, delete all that down. Perhaps, although I'd be interested in hearing from Bridget, and people who really drafted this, but then leaving the form in as a sample form. So delete that language that we've been talking about, because, there's, Marcia's right, there's a lot of things we need to decide, but leave the form in as just a sample.
Well, and even the part about the standardized form and what the panel might look like, and we haven't really talked about that, but, I'm okay with taking another stab at this and bringing it back too. I think where people are getting, my impression is we're getting hung up on the language about, maybe this is too much detail about how the audits may happen as far as the number of them. And we could take out that level of detail and just keep in the bigger picture part about, how the form might work. But I think Justice Tucker also raised some concerns earlier on with respect to the data collection and the entity reporting being confusing. And so in light of that, I would be okay in the interest of moving things along. We could take another stab at some appendices that we could, bring back to the SAGE subcommittee. I would be okay with that myself, but see what you think about it, Mary.
I guess my preference would be to pass, to approve something if we can today, and really not have the whole package brought back to SAGE.
Yeah, no. Right. Yes. I guess I just meant with like if I think somebody was suggesting we could take out Appendix 3 from the vote, and then we could come back with that one, but the rest of it we would move forward on, including the memo, I guess.
That would be fine. So then we would just be taking up these specific issues around, reporting and monitoring and the specific tools and mechanisms. That would be all right.
And to be clear, it would not necessarily be the highest priority item for you, because some of it really just needs to wait until other things have been determined. For example, in the scope committee about, what the restrictions are going to be on ownership and so on. So that would be relevant to what kind of annual entity reporting is required. But just that before we call this entire project finished, we should look one more time at Appendix 3. Can we see, Mimi, the language of the resolution and hopefully pretty simply add some words to the language of the resolution?
I'm not sure the resolution needs to be amended. We just need to take out Appendix 3 and the references to Appendix 3 in the memo.
Okay.
Well, the recommendation,
since the resolution is going to say as amended.
Yes, it was supposed to say as amended at the end of it, Mimi.
And
after audits, comma, as amended.
And so one of the amendments we will make is to pull Appendix 3. We'll just call that pending. There was one amendment that I just want to make sure everybody's clear on, and that it is what you all want to do, that was made to the memo itself. Someone struck some words in the memo itself. Oh, there we go. Just passed it, I think. Okay. So in the description in the memo, the regulator must also conduct regular audits to test for legal quality and accuracy of the services. It used to say provided by non-lawyers or software. We probably at least want the word provided. And I think Tom's point was that we probably don't want to just limit ourselves to non-lawyers or software, although it certainly seems like where services are provided by lawyers, the need for audit is less obvious, or maybe there may be less requirement for it, but we can address that when we refine Appendix 3.
I think we had already said that we were okay with that change.
Great. So do we have clarity with everybody now about the changes that we have made, so we know when we say we're adopting the proposal in the memo as amended, what the amendments are?
So I've struck this just letting you guys know,
Mhm.
because we're no longer referring to it as an example.
Right.
Just letting you know.
Kevin has a question or comment.
Yeah, just one quick clarification. You've been using the word pending and refining. So even though we're not going to be voting on Appendix 3 right now, there is a placeholder in place in this memo that we'll return to at some point that would end up being in Appendix 3. Is that correct?
I think that is the proposal.
Okay, thank you.
Well, you know, I don't know that that's true. We've taken out the reference to Appendix 3.
We're taking it out for now, but I think Bridget said she will work on it for us to consider in the future.
What, Mary?
Yeah, I'm just wondering if it would be, I'm not sure what it will, well, it's okay. I think we could just say if in the future. I'm just wondering if it would be possibly multiple appendices or, you know, it might look different than it does now just to avoid confusion, but I think we can get to that later.
I guess just in terms of trying to keep track of all this, and I would just rather personally, as the chair of SAGE and given what we have to do, I would rather just have a separate memo on reporting and monitoring that included auditing later. I don't want to be referring back to old memos that we've approved, and just, this is all so bureaucratic and hard as it is, personally.
Okay. So that's an undertaking to come back to us with something on reporting on monitoring, but it won't be called Appendix 3 is what you're telling us.
Right, exactly.
Got it.
Unless people have a different view and think that wouldn't be functional, but that would be my proposal.
I'd like a reference in the memo itself that we're voting on that actually says we're going to have a separate memo on reporting and auditing.
Agreed.
Okay. So in lieu of this paragraph that says Appendix 3 provides, could we have a simple sentence saying subsequent memo will address somebody else can write this if you want, but a
subsequent memo will address reporting and monitoring.
Perfect.
I would say a subsequent memo, just.
Yeah.
And maybe it's, well, maybe it would be examples of reporting and monitoring, because this memo still does give us the bones about what that will be.
Okay.
Right. Yep. I like that.
Well, why don't we say provide instead of address?
Okay. So now we have our placeholder that something further is coming on that specific point, and we have all the other amendments that we've discussed. Any reason we should not proceed immediately to a vote on Mary's proposal? Hearing none. Mimi, please call the roll.
Adding to my notes. Okay. Where's my voting slips? Okay. Marta Alkenbrock.
Yes.
Andrew Ruda.
Yes.
Mary Baldwin.
Yes.
Judge Wendy Chang.
Yes.
David Engstrom. Tom Green.
Yes.
Dan Grunfeld. Eric Helland.
Yes.
Kathy Huang.
Approved.
Micah Star Liberty. John Lund. Kevin Moore. Oh, thank you,
Yes.
John. Wendy Musell. Crispin Passmore.
Yeah.
Lucy Rica.
Yes.
Toby Rothschild.
Yes.
Becky Sandifer.
Yes.
Jim Sandman. Patricia Scutiero.
Yes.
Sasha Steinberger.
Yes.
Thank you.
Okay, good work, everybody. There are only 2 items left on our agenda. One is to talk briefly about the future, which we can do in a moment, and it will be brief. The other is to circle back if there is a request that we do so from Toby and or Marta to consider, I'm sorry, I didn't mean Toby, from Kevin and or Marta, to consider an additional point relating to agenda item 2B. So Kevin and Marta, do you want to ask for any additional action on this?
I have to apologize because I wasn't here. I was at a memorial service while this was being discussed. I'm not sure what you're referring to.
Okay, let me bring you up to speed quickly. We adopted Becky's memo almost exactly as it was proposed in the materials ahead of time. We did not make any changes to the memo to address in particular the desirability of having a study of the sandbox include what the impact on the court system might be, fiscal or otherwise. But I said it when we didn't have that added as part of the original motion, I said, you know, it's still timely on the agenda if there's an additional motion on this subject. And we can, but in part because you weren't there, Kevin, and in part because it wasn't part of what the motion was, we didn't, we didn't go forward with it at the time. I just said, hey, I'll circle back at the end of the meeting if there's a specific proposal to add to the list of questions to be addressed, I will entertain a motion. Since that's catching you by surprise, you probably haven't.
I have the memo. Okay. I have the memo in front of me, and I was writing notes as we were discussing it earlier.
So why don't you take a few minutes to think about those notes? Marta also is interested in this subject. Why don't I take the next agenda item, which is looking forward to the future, which will be very brief, and then we'll come back to this agenda item for whatever you and or Marta wants to propose, okay? Looking forward is quite brief. We have a SAGE subcommittee meeting on December 15th in the afternoon, I believe, a scope subcommittee meeting 2 days later, the afternoon of December 17th. Those are Wednesday and Friday in a couple weeks. Our next meeting as an entire working group is January 14th, a Friday in 6 weeks. And we have a whole list of future meetings that I hope you will review and let us know ASAP if you have any issues with. We also had some conversation about keeping some of the rules projects that started in September, one of them in particular going, and I don't know if anybody has been talking about that or working on that, but we may, if you're not already working on that, staff may circle back and ask you if you were previously involved in one of the rules projects, if you'd be willing to keep working on some of that as we go into the new year. Dan, do you have a question or comment about future direction?
I do, thank you. Just a quick reminder and a request. We were going to take a look on the whole topic of insurance or bonding. And I believe somebody in the state staff had volunteered to forward some materials that were developed in connection with the paraprofessional group. To the extent that has been done, and I missed it, I apologize. To the extent it hasn't been done, if that can be forwarded, so the SAGE committee can start looking at that, that would be helpful.
That's a very helpful reminder because I know from talking to Mary Baldwin that that's a topic that she's hoping SAGE will get to soon. So State Bar staff, if you could please connect with Dan so that he can help Mary be prepared for that to show up soon on the SAGE agenda, that would be great.
Yes, and thanks, Dan. I'd forgotten that you volunteered to lead that, so thank you.
I did receive some materials from Linda Katz, the staff person for the paraprofessional working group, and I think I shared it with Bridget, but I will share it directly with Mary and Dan. So they have
and John, thank you.
And John, thank you.
Super, thank you all. Okay, unless there's anything further on future direction, we will now circle back. Okay, Kevin, circling back, and hopefully a couple minutes to look at your notes was helpful. You want to make an additional motion?
My motion is just to add a 5th category of questions to Becky's memo that would look at, in addition to access to justice, impact on lawyers, legal services, efficacy of Sandbox and consumer protection, to look at any impact that the Sandbox might have on the court system, that there is an appreciable increase in legal services. And as I mentioned earlier this morning, perhaps closing the information gap and making people more aware of their legal rights that they might bring to the court. My idea was it might have an effect on the need to increase funding of courts. Toby, though, also raised the issue that it might also suggest that the court should consider simplifying some of their procedures to make themselves more accessible to folks who are using or trying to access the courts through means other than traditional lawyer representation.
Okay, so that is on its way towards being a motion, but can I suggest that we could put, where we have impact on lawyers and legal services markets, we could simply make it impact on lawyers, courts, and legal services markets, and then we could have a question: what impact has the Sandbox had, if any, on the court system? Or we can leave that out. What impact has the Sandbox had on the court system?
My suggestion is the court system. I think we're all aware of our sister working group, the Paraprofessionals. And there is a listserv that somehow I got on one of my local bar associations to which I belong. And there's an uproar over the paraprofessional proposal, which should surprise no one. But what many people equate access to justice, lawyers, is access to the court system. So I thought that it would make sense to separate out the impact on the court system as a separate topic that should be studied.
Okay.
It was just a suggestion. That's I'm not entirely wedded to it, but that's why I suggested it as a separate.
Well, the
caps.
hardest trouble I'm having is coming up with the questions beyond what impact has the Sandbox had on the court system, because I heard some thoughts, but not a specific research question. And the advantage of just stopping with what impact has the Sandbox had on the court system is that it includes financial and non-financial and all kinds of other topics within it without having to.
Well, I mentioned the one
limit.
thing. Has the Sandbox closed the information gap recognized in the Closing the Justice Gap report that makes the court system or makes folks more interested in vindicating their legal rights. Secondly, and this follows with the first question that I just quoted or just suggested, is does that closing the justice gap also warrant the court to, or closing the information gap warrant that the court make services more available to people who are trying to use the court system without the aid of lawyers? And give me a little time. I can probably come up with a few more questions we can follow up at some point. But the main point is I'm just suggesting that we just have this topic, that I think it's an important topic.
Okay, well, I understand you want it as a separate topic, so your proposal is that we add as a separate topic. Never mind my prior suggestion. And if you, Marta, you were also interested in this. Oh, and in the meantime, we have comments from Leah and Neil. So let's see if we can kind of round this out before we vote on it. Leah, you want to go next?
Sure. I think some questions could be centered around looking at the number of self-represented litigants. So I think that would be one, the number of proceedings that proceed in default, like you'd expect to see that reduce. So those are some questions or areas to explore, I think.
Okay, thank you. Neil?
Yeah, I was going to suggest exactly the same 2 points that Leah just suggested. I was going to also add maybe effect on filings and dispositions overall, right? The only thing I will say, comment on it in terms of looking at changing how people access the courts, I think that may be outside the scope of what we're trying to do here. And in any event, the JC is on its own been doing a number of efforts in that regard. So I wouldn't want something out of this group to sort of conflict with what is happening out of the council's efforts. So just flagging that too.
Okay, so that's helpful. Both of those comments are helpful, and let's see if we can use that to help us make friendly amendment suggestions to Kevin about his proposal. Marta, I don't see your hand raised, but I know this was a topic you were interested in. Did you have other things you wanted to say, ask, or suggest on this?
I like, and if to the extent Toby needs a second, I can second it. I think there's some wordsmithing we can do here, but I think what I liked in particular, what he said about simplifying the court processes. I think that I don't know that there's anybody in this meeting who would not agree with something like that. I think we can all agree that the court could simplify a lot of things to make it easier on self-represented litigants and frankly, even represented litigants. And so I'm in favor of these additions with some, wordsmithing to make it easier on people's eyes. And if that's fine, if that's good, it's hard to do this kind of on the fly.
Okay. Kevin, do you want to make any further changes to the proposal that's up here? Or does anybody else want to suggest any further changes to the proposal that's up here? And Mimi, is it all there or is some of it on another page?
No, this is it. This was other stuff that they talked about
Okay.
that I don't think would fall under that category.
Okay. Okay. On the first question, you can take out going to be. What is the impact? Because we're talking about studying the project after it's been underway.
The second bullet point, it's really just, it doesn't really connect the dots. What I was trying to say, do you close the information gap, thereby increasing the number of filings or increasing the use of the court system is really what I was trying to get at. That people learning of their rights, learning that they do have these legal issues, are they availing themselves of the courts to a greater extent?
So how about now?
That's fine.
Don't we want to know if the sandbox has achieved its goal per the report through our charter?
Well, I think that is very much what the series of questions already on the board is designed to address. Leah, do you have an additional comment or is that a vestigial hand?
No, it's just a question, and my apologies if I missed this. I'm just wondering about the focus on closing the information gap, because there are going to be other, hopefully, potentially positive benefits of the sandbox beyond closing the information gap. For example, making legal services more affordable. So it's not just, I may have known all along that I have a legal problem. Right. And so I'm just wondering, in terms of these questions we're drafting on impact to the courts, we're focusing it pretty narrowly on the impact of closing the information gap. And I'm wondering if that should be broadened. It's not just the information gap. It could be just affordability increases access and thus has these results as well.
Well, in some ways, the second point is a subset of the fourth point, but Kevin may wish to have it called out separately. I don't know. Becky.
Just a couple of points to see if maybe we can make this a little simpler. So if you looked at what's already been approved, the second resolution is asking for an independent evaluation of whether or not the sandbox achieves its goals. So that's already in what we've said is important to do. The information gap is currently under access to justice as the last bullet point. There it's called the knowledge gap. And it doesn't, it's just sort of asked straight up, does that get reduced? I certainly endorse Kevin's point that effects on the court are something that we would want to know about. And so I certainly am happy to see that there. But some of what we're talking about here seems to me to be already included in what we approved earlier today.
So Kevin can think about whether in light of that, he's willing to drop question number 2 and just leave the court's aspect of it addressed by question number 4. Maybe if you could go back to the court's questions. But Marta has something. Unless that's vestigial.
It's not. I don't know that number 2 is necessarily incorporated in that section, that the first section that Becky referenced. And maybe what that bullet point number 2 says, instead of has a sandbox closed, the justice gap, and just period, end of story, because I think that is what we're trying to accomplish. And I think that's worth just saying as simply as that. Because at the point that I think Becky referenced, it talked about funding, and then, I think that's a separate issue.
Marta, the point that Becky referenced on the last bullet for access to justice, the question is, are sandbox entities reducing the knowledge gap? And then in parentheses, she explains what she means by that.
I meant the first one. I meant the first bullet point, or maybe it was number 2. I don't remember. I'm sorry. It's hard to, I'm reading off my screen and not off my, and maybe what I can do.
It is hard to do, which is a reminder that's why we hope people will read the memo and make comments in writing ahead of time so that we don't have to do it on the fly in the meeting. But
could I make a recommendation to take out the second bullet point, and I think the third bullet point more accurately captures what I'm trying to say.
Okay. So it's your motion, so that's done.
The point that I was making, I'm sorry, was Becky referenced funding should be provided for a vigorous, independent, and impartial evaluation to be conducted at appropriate intervals of the sandbox and how well it achieves its goals. My suggestion was simply, does the sandbox achieve its goals, period? And rather than tie it to funding. That was what I was referencing earlier. Sorry about my clumsy attempt to reference Becky's earlier comments. My apologies.
No apology necessary. Is that something you want to have as a question under impact on the court system?
Yes.
Okay. If it's fine with Kevin, we'll add it.
Sorry.
Fine by me.
Mary, you have a question or comment, Mary?
Yeah, I just, I was going to say, with respect to the bullet point we just took out, that I thought it was an awfully lofty goal we were imposing on the sandbox to close the knowledge gap. So we took that bullet point out. so now the second bullet point, I'm not sure I completely understand. It doesn't even grammatically seem to work for me. Has closing the knowledge gap warranted the court to make more services available? I'm not sure what I understand what that means. And I think by referencing closing the knowledge gap, again, we hope that the sandbox will help close, the knowledge gap, but asking the sandbox to close the knowledge gap as it's been defined and described in the prior report seems an impossible task. And I can't believe that's what we're expecting the sandbox to do.
Okay, Dan.
Yeah, I had exactly the same reaction as Mary. A justice gap that took maybe 40 or 50 years to develop is not going to be closed by a sandbox in 2 or 3 or 5 years, or however long we end up doing it. Let me make us a friendly amendment. I would just make this one bullet point, one question: the impact on the court system, including but not limited funding, and the information now contained in bullet point number 3, having to do with number of litigant per se, et cetera. What we need to focus is on stuff that is measurable, that can be quantifiable. I'm not sure that the knowledge gap is something that is easily, readily quantifiable. And if it is, we have limited, but not limited to language for the regulator to look at.
Okay, so you think your friendly amendment would be a single question: what is the impact of the sandbox on the court system, including the number of self-represented litigants, defaults, filings, and dispositions?
No, and include funding, including but not limited to funding, comma, and then the things that you just read.
Not limited to funding.
Including but not limited to such areas as funding, the number of self-represented litigants, defaults, filings, deposition, etc.
Okay. So that is a proposed friendly amendment. Kevin and Marta as motion maker and seconder. How do you accept that or no?
I would accept that as a bullet point.
Okay. He was proposing it as a replacement for the bullet points, so that it would be a single bullet point under impact on court system, as I understand it.
That's correct.
Well, since we're trying to quantify it, should you include the concept of increase or decrease?
If
in
sure,
the number of
you want it in there, that's fine. Impact could go both up or down, but that's fine by me.
Okay, Mary?
Are you asking, does this address, I'm not the maker or the seconder.
You had your hand raised and I.
Oh, sorry.
Okay.
Yeah, thank you.
Okay, I think we're getting close on the replacement question. So Mimi, the 5th word or something needs changing. What is the impact of this sandbox, or what impact does the sandbox have on?
Or what impact has the sandbox had on?
That's fine. I don't know if Kevin cares about these various forms. I just want something grammatical. So what impact has the sandbox had on the court system, including but not limited to funding and the increase or decrease in the number of self-represented litigants, defaults, filings, and dispositions? Kevin, does that capture what you want the question to be? Okay, Marta, are you accepting as a friendly amendment that is now the motion?
I am.
Excellent. Any further discussion of this motion? Well, I think we put all the discussion into the coming up with the one question. Well done, team. Let's have a vote, please, Mimi, if you can call so the motion is to add this heading and this question to the list of questions already approved in today's meeting. So understanding that that's the motion that Kevin has made and Marta has seconded. Tiffany, you can call the roll.
Okay, Marta Alkenbrock,
Approved.
Andrew Aruda,
Abstain.
Mary Baldwin,
Approve.
Judge Wendy Chang, David Engstrom,
Abstain. Sorry, abstain.
Tom Green,
Yes.
Dan Grunfeld,
Yes.
Eric Helen,
Yes.
Kathy Huang, Micah Star Liberty, John Lund, Kevin Moore,
Yes.
Wendy Mussel, Crispin Passmore,
Yes.
Lucy Rica,
Yes.
Toby Rothschild,
Yes.
Becky Sandifer,
Yes.
Jim Sandman, Patricia Scutiero, Sasha Stein.
Yes, sorry.
Thanks, Patricia. And Sasha Steinberger.
Yes.
Thank you.
Okay, thank you all. I believe we have now gotten entirely through our agenda and we have finished an hour and a half early. Is there anything that anybody on the points that are already on the agenda, which pretty much limits what we're allowed to do today, is there anything that anybody else wants to raise for discussion or action before we adjourn? Bridget.
I was just wondering, since we do have a little bit of time, if it might make sense to debrief, or if anybody had any comments or questions about the presenters this morning, just as it's impacting what they're thinking about, the decisions we're making, and maybe other speakers that they might like to see come forward. So I just thought, since we had some time, it might be worth processing that a little bit with the group.
Sure, I thought they were fabulous. What comments? Let's see, Wendy has a question or comment.
So my only comment is that I think this is one of the first speakers that has really focused on something I've been talking about throughout, and that has not been addressed in a lot of the public comment that we have been receiving, is that there's an entire class of people who do not have access to justice in the form of people who are being sued. And I really liked that. I think it gives a much better presentation of the true access gap as I see it from the court's perspective. And I thought that was really good.
Other questions, comments, or suggestions for who you'd really like to hear from in our coming meetings? Andrew.
I thought it was really good to have Erin in particular, because she was talking about how, as an attorney, the rules in place with the paralegals still are, not where they need to be, as far as her being able to hire engineers and have kind of a more modern practice. Because when I stepped back and I knew about what she was up to, but I didn't really know how she does it. It just sounds like she's trying to run a modern legal practice and have engineers and other folks and be able to compensate them appropriately and include ownership with them. So it was just really neat to have someone take theory into practice and be someone who is doing exactly what we're hopefully architecting and enabling.
Crispin.
I thought both speakers were excellent. The next step for me would be to hear from some investors about what makes the legal market interesting to them and what they think of professional ethics and how that fits with the ethics of their own industry.
Crispin, I think that's an excellent suggestion. I appreciate you raising it, and would ask that you work with someone on State Bar staff about particular people who might speak at our January or February meeting.
Okay.
Marta.
I also agree. I think that would be a great a speaker. I had a slightly different opinion with respect to the Hello Divorce speaker. I thought she was great. I think she has a very interesting business model. But I am curious, her attorneys are still making substantial salaries. The reason why she wants the rule changes for her business is that she can pay paralegals and others on her staff in equity as opposed to just straight salary. My confusion with respect to that analysis is you can pay people about the same or more by salary. So you don't need to give an equity increase or an equity holding in a business in order to pay them or compensate them fairly for the services rendered. So, and I also don't know how much she's really closing a justice gap with respect to people that need to get a divorce and who otherwise cannot hire an attorney because, they're paying about the same. There may be streamlined services that she's providing, which is great, but I don't know that that's necessarily what's needed to close a justice gap or be a participant in a sandbox. That's all.
Thank you. Leah.
Yeah, I had a different reaction to the Hello Divorce presentation. I thought it was actually significantly cheaper. There was the $700 a month for 5-month option, $3,500, and that compared to the $17,000 or $26,000 divorce fees that she cited with or without children. So I thought it was quite clear that it was cheaper. What I've also heard is the reason for the equity interest is that at the onset of starting something new, you can't afford to pay the salary. So the equity interest is how you get people to participate for the first year, 2 years, 3 years that it takes to become profitable. So that was kind of my understanding of what she was saying. And I thought they were both compelling presenters. I appreciated them coming forward.
Sasha.
I just agree with that. I think it also highlighted how hard you have to work to try to make the system work right now to be innovative and how many things you have to work around. And she's been tenacious and figured it out, but we shouldn't make it that hard for people to come up with innovative ways to have lower cost options and more accessible options. I also, just to piggyback on what Crispin said, investors is great for the for-profit world, for the nonprofit world. Which funders are going to pay for these kind of programs and the additional staff outside of program staff, the overhead it's going to take to set this up, the data people it's going to take to set this up. So if you guys have ideas about that or have other people who might come speak to the group on that, I think that'd be really important as well.
So picking up on that thread, I know that the Legal Services Corporation has a series of grants that they make for people providing innovative legal services. And did we hear from somebody from that program early on? Or maybe I was just reading something, but we have some folks with much better context than I have with the Legal Services Corporation. And maybe that is another potential presenter, as Sasha says, sort of as a parallel, thinking about funding for Sandbox participants. So if State Bar staff could think about following up with Sasha and with our colleagues who have good contacts in the legal services community. Tom and then Eric. Tom, you're on mute.
Sorry. Yeah, I was struck actually by a couple of things. I did like both of these speakers. They were very helpful. I was struck by both of them talking about ambiguity being the enemy of being able to deliver services. I mean, I thought that was the thing that immediately came to mind. If it's not clear, does the bar need to sort out a process whereby people can find out if a paralegal does X, is that over or within the lines that we propose? And the second thing that really struck me was how minimal the ad was that they thought they needed in order to deliver these services. So I think that clarity issue from a regulatory perspective, I think would be very helpful. And then to Crispin's point, which I think was well taken, an investor or investors would be interesting. I think it would be really interesting for us to get a better bead on what a VC firm gets when they're deciding to give somebody some money. my experience is they ask for a lot. And we have these extended discussions about, we don't want to burden people with disclosures and this and that. If you get a dime from a VC, you produce a lot of information. So we should not be shy to stay in that same ballpark.
Eric.
I was actually in a similar direction to Tom's going, but only in the nonprofit. It'd be interesting to hear from a program officer from one of these funders, kind of about what they're looking for in terms of information they're collecting from monitoring purposes. Because I worry a little bit about burdening the nonprofit sector with some of the regulatory reporting. And it'd be interesting to know what, say, the Hewlett Foundation is asking from people that they're giving money to in terms of reporting, just because, to try to set the bar at a level, we know people have been willing to take grants and provide these services with whatever their reporting requirements are. I'm sure they have them, and I'd just be interested to hear from Hewlett or one of the other funder program officers if they're willing to talk to us about what those look like. So we're not setting the bar too high for the nonprofit sector, which I think, has been mentioned, it's going to be a key part of this.
That's a helpful suggestion. And maybe a variant on the second request for speakers, that is to say, on the Legal Services Corporation funding type speaker. Andrew and then Toby.
I was just going to say two things. One was, and Leah touched on it, I think what Erin was saying about the equity was precisely about the beginning, where you can't have a huge budget to pay a bunch of people. So just wanted to double click on that. And then a comment that was just made about VC. I've raised over $20 million in venture capital so far in my life. And depending on the stage, there's different reporting requirements. And early on, actually, VC are quite light about what they are looking for in terms of reporting, for precisely the same reasons as we've discussed here, where you don't want to kind of burden early stage folks with more reporting than building. So just wanted to add that perspective because I've lived it.
That's very helpful, lived experience. Toby.
Yeah, on the nonprofit side, I think you've got a number of places. I think Rohan identified a number of sources that he gets fund money, might be a place, be able to connect us with someone who would be willing to talk about what he's looking for. There's also a group in the Bay Area called the Legal Services Funding Network. That is a network of foundations and funders that gives funding specifically to legal services programs, and you might want to talk to somebody from there to see if they can be of some help.
And Toby, do you know folks there, or does anybody else in this meeting know folks at the legal, what did you call them, Legal Services Funding
Network? Yeah, I think they work with the state bar on some stuff. I'm sure that some of them are familiar with that.
We have a relationship with them.
All right, super. Does sound promising. Other suggestions about who you would like to hear from, or anything else relating to future directions, subcommittees, or for our committee as a whole? All right, well, we don't usually finish early, but we got a lot of good discussion and decision-making done. And I think I appreciate that everybody has agreed to participate in committee meetings in the middle of December, because I know the month only gets busier for folks. But thank you, and I'll probably see some of you on those calls. And then otherwise, I will see you all in the middle of January. Take care. Have a good afternoon. Bye-bye.
Thank you, everybody.